Not yet.
Okay.
All right, Mr. Chair, you are recording.
All right. Good morning, ladies and gentlemen. This is the March 25th, 2021 regular meeting of the Board of Adjustment for the Municipality of Anchorage. I'm Robert Stewart, the acting chair. Madam Clerk, would you please call the roll?
Yes, Mr. Chair. Mr. Stewart.
Here.
Mr. Diak.
I'm here.
Ms. Peace.
Here.
You have a quorum.
Okay, it looks like we have a quorum. Before we get started here, I'd like to recognize our esteemed clerk, Jennifer Venneklassen, and if I mess up some names, feel free to correct me. And our board counsel is Dennis Wheeler, attorney at law. And I noticed that we do have visitors in the audience. So with that, I would like to talk to the visitors just a second before we get going. I would note that this is not an evidentiary hearing. We may not hear arguments and may not take additional testimony or other evidence. Our consideration is based solely on the record before the lower administrative body plus notice of appeals and briefs. Participation is encouraged, but you may not address our prior decisions on this case. What I'd like you to do is to please keep your microphones on mute for the visitors while monitoring this meeting. At the end of the meeting, I plan on asking the audience if they have any questions or comments. Okay. We're doing this on a teleconference. So if you want to speak or want to intercede, hit the hand up. And if I don't catch it, Jennifer can catch me, or you just go ahead and interject when there's a chance so that you remind me that you're there. Okay, let's take a look at the agenda. We need to approve that. Does everyone have a copy?
Yes.
Okay.
Yes, Mr.
Are there any changes, deletions, or additions? Okay. Seeing none, and hearing, in case we have people that can't.
No changes.
I don't have both, so I'm hitting both areas. Therefore, the agenda is approved. I'd like to look at the previous minutes. Let's take a look at the January 20th, 2021 minutes. Do we have any additions, deletions, changes, or any recommendations?
No.
Okay, hearing
Mr.
and
Chair,
seeing.
may I have a question on
Yeah.
process? Are
Yes.
we gonna approve them together or individual motions?
Well, I want to look at them individually unless we can, if you're comfortable, if you've looked through both of them.
Yes, that's why I'm asking. Currently, it's listed as one item on the agenda. That's why I'm asking.
Okay. We can address it both at the same time if you're comfortable doing that. Are there any objections or changes, deletions to the minutes? Both sets of minutes.
None.
Mr. Chair, I would move to approve the minutes from January 2021, as well as February 26, 2021, as stated.
Okay.
Second.
Any objections? Seeing and hearing none, the minutes are approved. Okay, going into old business. Wanted to give you an update on our cases that were filed with us earlier with the Board of Adjustment is 2020-2 and 2020-3. They're involving plating board case number S12545. The plating board has decided to reconsider S12545. Now, what this does is that it may, in fact, moot one or both of the appeals, or it may change the nature of the appeals. So the chair of our board on 14 December 2020 ordered the appeal stayed pending further decision by the planning board. So that's the latest information that we have. Madam Clerk, do you have any further information on these two cases?
Not at this time. You might ask Mr. Wheeler if he wants to weigh in, but I don't have anything further.
Okay, Mr. Wheeler, you have anything?
Yes, Mr. Chairman, we're anticipating the written decision from the lower body to be issued or approved on April 7. Both parties have filed motion work with the clerk's office to be addressed by this body, but since we don't have the decision yet in hand from the lower body, we have not worked those motions or prepared anything for you to consider. So once we have the lower body decision, we'll prep something for this board and get it on your next available agenda after we have that written decision approved by the lower body.
All right, thanks very much, Mr. Wheeler. That takes care of the old business. On the new business, we've got before us the Board of Adjustment Appeal number 2020-4, and that relates to Planning Commission case number 2020-0097, also known as the Powder Run Multifamily Residential. What I'd like to do is look at any potential disclosures of potential conflicts of interest. So I'll start with Mr. Diak.
Yes, Mr. Chair, reviewing the packet, I found that I'm familiar with several of the commissioners. It's not unusual in this town to know of the commissioners, but I do not have any conflict to report, and I'm ready to participate.
Which commissioners are you referring to, P&Z or Board of Adjustment?
I'm sorry, P&Z. In this case, I'm already talking about the case in that regard. No, obviously I know you all, but I meant the reviewer body, lower body, has members who I am familiar with. I know them, but again, I do not see that as a conflict to participate.
Okay, I don't think that's a conflict either. Ms. Pease.
Yes, I don't believe I have any conflicts like Mr. Diak. I know a planning commissioner. I know I've had interaction with Ryan Yelly of the planning staff, but I don't believe I have any conflicts.
Okay, do either of you and myself, I have no potential conflicts of interest to declare in this particular case, but do both of you agree that you will not let your relationships interfere with our discussion of this case and deliberation on this case today?
Agreed.
Yes.
Okay, thank you. Okay. Before we go any further, I'd like to cover some hearing requirements set forth in AMC 21.03.050 for the benefit of the audience. That provision says that the Board of Adjustment may not hear argument or take additional testimony or other evidence. The Board of Adjustment is constrained by matters that are in the record established before the lower administrative body. Now, the reason I raise this is that it appears we have one brief that may contain items that are not part of the record before the P&Z Commission. So by law, we cannot consider those items which are not part of the record before the Planning and Zoning Commission. I would note now that we did have the opportunity for our board counsel to prepare a memo for us, and he has kindly divided the case into a number of issues. So I'd simply like to go through those issues one by one as they're raised in the memo. And what I'd like to do with your concurrence is I'd like to sequentially number the findings and the issues when the findings start being developed. I'd like to start with the number 1 and then carry it forward, and the same thing with the issues. Start with number 1 and carry it forward. Council or members, do you have any problem with that?
Mr. Chair, no problem on my part. I would request that Jennifer keep track of the items as we go through, because there are, I think, quite a few. But other than that, I am perfectly happy with the solution.
Okay. Any other comments?
Yeah, if there are any issues that I felt were in the briefs, but not in the council's overview, then we'll see. If we don't get to those, I'll chime in at the end if that's okay.
Okay. Now, before we get into the specific issues, we've got to address several, or I'd like to address several issues, or not issues, just call them items right now. One I'd like to get on the record is I noted that our board counsel has aptly pointed out that there may be some confusion in the use of the terms MJ3 and 3MJ as they refer to the applicant, which is also the appellee. The conditional use application at the record R-025 and the planning and zoning resolution 2020-025 at R-134 both name the applicant as MJ3 Development LLC. However, the letter of authorization at the record .028, the dowel narrative starting at R.029, and the dowel representation before the Planning and Zoning Commission at T-023, and the appellee's brief throughout refers to the appellee as 3MJ. So with that in mind, for clarity purposes, I propose that we use 3MJ when we do refer or have to refer to the appellant or appellee by that particular nomenclature during this meeting. Are there any objections or concerns?
3MJ.
Yes, 3MJ.
Fine with me.
Okay.
No objection.
Some preliminary issues we need to look at. In addition, there are some preliminary findings that we need to address, including jurisdiction, both for our board and for P&Z's hearing. And then we've also got some validity issues regarding P&Z. So first, I'd like to address the jurisdiction, and I propose the following finding: the Board of Adjustment has jurisdiction to decide appeals from decisions of the Planning and Zoning Commission regarding the approval or disapproval of a conditional permit in accordance with AMC 21.03.050A.1 Do I have any objections, or let's first of all, do we have any discussion? Any objections?
No objections, Mr. Chair.
None.
Okay, seeing and hearing none, preliminary finding number 1 is adopted. Okay, I'd like to look at the other part of the jurisdiction for P&Z. And I'd like to propose the following preliminary finding. Planning and Zoning Commission has decision-making authority for the approval or disapproval of conditional use permits in accordance with AMC 21.02.030B.1. Any discussion or objections?
No objection, Mr. Chair.
None.
Okay, seeing and hearing none, preliminary finding number 2 is adopted. Now we need to look at the action of the validity, or the validity of action of the Planning and Zoning Commission. Little background, so that you know what has happened here, thanks to our council, the version that I was operating from was the gray version like this, and there was an amendment to that in April of 2020, and that's when the Assembly moved Planning and Zoning Commission membership and quorum requirements from the Anchorage Municipal Code of Regulations, and they put it in the Anchorage Municipal Code as 21.02.030D. This new section D provides a majority of full membership of 9 P&Z commissioners constitutes a quorum, and actions taken by P&Z requires a majority of full membership. On the August 3rd, 2020 meeting of the Planning and Zoning Commission, there were 8 members of that 9 full seats participating. I propose to make findings on these requirements just for the record. I note also the transcript at T001 and T002 supports the proposed finding on majority and quorum required to conduct business, as 8 of the members of the full 9 of the PNC were in fact present. So preliminary finding number 3, I propose the August 3, 2020 Planning and Zoning Commission meeting had 8 participating members of the 9 seats of the full commission, constituting a majority of full membership and a quorum for transaction of business in accordance with AMC 21.02.030D.1. Any discussion?
None?
No discussion.
Any objections? Seeing and hearing none. Okay, seeing and hearing none, preliminary finding number 3 is adopted. Okay, I'd like to also make another finding that goes to a favorable vote of the majority that's required by code. So I propose preliminary finding number 4, the August 3, 2020 Planning and Zoning Commission action to pass and approve the conditional use permit by a vote of 8-0, followed by adoption thereof on September 14, 2020, met the majority vote requirements of AMC 21.02.030 Delta D2. Any discussion or objections? Okay, preliminary finding number 4 is approved or is adopted.
Just that municipal
Yeah.
code cited in our brief from council said D1, Delta 1, but I don't have that before me. And I believe I heard you say Delta 2.
Okay, council, did I misquote that section?
Mr. Chairman, I think you're all right. D1 requires a majority of the full membership to constitute the quorum. D2 requires that you have a majority vote of the full membership to pass an item.
Okay.
And this CUP was approved by an 8-0 vote, so they certainly had the majority required to pass the item.
Okay, so that is D2, so that's correct. Okay, now we're going to move to the section on the record on appeal. And I note again that parties are not permitted to introduce or submit documents or evidence to the Board of Adjustment, which are not part of the official record. The appellee's brief filed on January 26, 2021 has 4 attachments. Attachment A is a copy of the record at R-008, and attachments B and C appear to be pages 48 and 49 from the Girdwood plan. And I also note that the plan itself or these documents were not placed in the record in front of the P&Z before decision. And then the other one is attachment D. It's allegedly an undated photo of the subject property. And again, this was not placed in the record before the P&Z Commission. So those attachments B and C and attachment D are the ones that are at issue. So we need a motion regarding attachments attachments B and C to get this issue up to the floor. I would ask motions be worded in a positive terms of a statement. And that way, I think it precludes us having to go back in and have another finding to overcome possible issues or findings that are addressed with questions. So as an example, on this one, this is issue number 1. It could be phrased attachments B and C submitted as part of appellant's brief filed on January 26, 2021 shall be considered as part of this record. Can I have a motion to that effect?
Mr. Chair, I
Yes.
would make the motion that we, the Board of Adjustment shall consider attachment B and C as you stated for the case.
Okay, is there a second?
I'll second that.
All right, moved and seconded. Mr. Diak, would you like to start the discussion, or would you want me to do that? We'll give Nancy Pease a break because this is her first meeting with us.
Yeah, well, I don't mind to start. If you you insist, I will be very polite and let you do it, but I'm happy to jump in.
Okay, go ahead.
In this case, we have the pages from the Girdwood area plan as the issues as attachment B and C in the appeal, and we have used those planning documents for decisions consistently in our land use boards to make informed decisions about land use matters in front of the Planning and Zoning Commission. In that light, I do think that allowing those pages from an adopted plan is a proper course of action, and I would support the motion.
Okay, Ms. Pease, do you have something to add?
No, I would just view an adopted plan as a de facto document of record that I would assume the planning staff and the developer would have consulted. So I'm fully on board with considering them part of the record. Attachments B and C.
Okay, and for the record, the briefs filed by the parties did include, or they're supposed to include copies of the code and regulation principally relied on, and an excerpt of the record on the briefing. But that's why this issue is up here partly. But I would like to also note that the Girdwood area plan, which I'll call GAP, is discussed at the staff report at page R-009, and it's in the appellee application at R-030 and R-037, and it's in the P&Z 8 August hearing at T-020. And I also note the GAP was not physically in the record. That's why we're looking at this today. But I also want to point out that the Girdwood area plan is part of the comprehensive plan, and that's set out in table 21.01-1 of AMC 21.01.80. And as such, it is part of the Anchorage Municipal Code. And with that in mind, we can look at those two attachments B and C, but we can also address the entire Girdwood area plan if that is needed in appropriate matters before us. And also note that it's code principally relied on by all of the parties. So I intend to support this motion. Any further discussion? Anything from Mr. Wheeler?
No, sir.
Okay.
Mr. Chair?
Yes.
I would just like to reiterate that as much as the issue is 2 pages from the Girdwood area plan, which was specific to the brief of the appellant, I do think that your statement about having the whole document being considered part of the record is the proper action, and I would support that avenue to move forward.
Okay. And that's part of the reason this is before us, because of the requirement, if they rely on a piece of code, they're supposed to put it in there. But in this case, the code is in fact part of the B and C is in fact part of the code. So that's why we're looking at that. Okay. Madam Clerk, I think we're ready to vote on this.
All right, Mr. Stewart,
Yes.
Mr. Diak,
Yes?
and Ms. Peace.
Yes.
That motion passes 3-0.
Okay. I'd like to discuss for a minute corollary findings. When we, in the past, when we've gone through corollary findings, those findings are usually held up and then discussed a little bit later because they could be changing as we go through the case. But in this particular case, I'd like to put a finding in here just because of the way that what we discussed in the motion, and that would be I would like to call finding number 5. The Girdwood area plan is part of the municipal code by virtue of it being included as an element of the comprehensive plan set out in table 21.01-1 of AMC 21.01-.80, and its code principally relied on by all parties. Are there any discussion? Okay. Any objections?
No.
Okay.
No objection.
Finding number 5 is adopted. Okay, let's go on to issue 2. Attachment D. The question was initially raised as should the attachment D, which is the photo, be considered as part of this matter. I would like to phrase it in a positive statement, that is, and call it issue 2 is attachment D. It's an undated photo and it's labeled trees removed from lot and surrounding neighborhood of the single family housing, was submitted as part of appellant's brief on January 26, 2021, and shall not be considered as part of this matter.
Mr. Chair?
Yes.
I would like to make a motion that attachment D, I move to include. I move to have attachment D to be considered for part of this matter.
Oh, do you want that considered as part of this matter, or not?
Well, I have to make a positive motion, so I started with that.
Okay. You want it to read shall be considered or shall not be considered?
Shall be considered, yes. Sorry,
shall be
yes.
considered. Okay. Is there a second?
Second.
Okay. Ms. Pease, would you like to start the discussion on this one?
Well, this one's a bit more complicated in my mind. We're bound to exclude evidence that or documentation that was not part of the planning and zoning's original packet. We don't know at what point this tree clearing took place, so we don't know whether this evidence could have been included at the time. So on that basis, it would seem that this evidence would not be admissible. On the other hand, part of the findings of the commission had to do with mitigation to the maximum extent feasible, and there were pledges made by the 3MJ to retain 25% of the natural vegetation, with trees being the main intention there. And this does relate to that promise. The promise wasn't one of the conditions. It was a point of discussion. It was, I guess, a commitment of some sort. This does relate to that. And again, I don't know whether this evidence could have been presented during the planning and zoning case because we don't know the date of the clearing. So I think it's more complicated and would like to hear the more experienced members of the board speak on it.
Okay, Mr. Diak.
I guess I'm the more experienced member to start then. So, Mr. Chair, I do believe that our rules are very clear on our procedures, reviewing only the record as evidence for our decisions. I do also believe that this particular attachment has not been a part of the record based on what my review tells me, reviewing the record. And I consider this a procedural issue where I do believe that this evidence shall not be admitted at this time because our rules are requiring us to consider evidence that was part of the record. And in that light, I will not support the motion for those procedural reasons, noting that you can't not unsee the picture. Obviously, we have seen it in the brief, and that raises questions Mr. Pease alluded to, but I do think there are other avenues to address those.
Okay. I agree that this is evidence that should have been could have been presented in front of the P&Z, but it is not part of the record that was addressed by P&Z. So with that, I can see no evidence in the record at all that related to that the photo was part of the record. No evidence that the photo was raised or discussed in the transcript of the P&Z hearing, and there's no assertion by the appellant that the tree clearing exceeded what might have been allowed by right, or that the appellee 3MJ violated the law relative to clearing or retention of trees. But what this boils down to is that we cannot add evidence or hear evidence or testimony given after the decision is made by P&Z. We are relegated to looking only at the record before us and what was before the P&Z. So I intend to support no, I do not intend to support this motion as it is stated. Is there any other discussion? Okay.
I would just say that I think that clarifies for me that we are bound to exclude this photo because it was not part of the original record. And again, just state we don't know the date of this. So it's possible that it could not have been included, but that's not our issue. Our issue is that it was not included in the record before P&Z.
Okay, Madam Clerk, I think we are ready to vote.
Mr. Stewart,
No.
Mr. Diak,
No.
Ms. Peace,
No.
that motion fails 3-0.
Okay. I would like to come back to this and address a possible follow-on finding after we get through with some of the other issues. And the reason, well, I'll address that when we get back to it. Okay. Issue number 3. It is, shall exhibits attached to the appellee's reply brief be considered? Can I get that? Can I get a motion to address the 4 exhibits attached to the appellee's reply brief dated February 23, 21 shall not be considered as part of this matter?
Mr. Chair, again, a clarification. Do we still continue with positive motions?
Well, what I meant by that is it's positive in that it's as a statement, but rather than as a question.
Mr. Chair, I would like to make a motion then.
Okay.
The motion is that the Board of Adjustments shall consider the exhibits attached to the appellant's reply brief as you stated in your previous statement.
Okay. And I will second that. And also note that the attachments refer to a Girdwood Board of Supervisors letter of objection, and it's referenced the variance request in a case different from ours, dated February 28th, 2020. And I think it was probably written to the Municipality of Anchorage Planning Board. And then there's also the Girdwood, it's just the Land Use Committee meeting minutes, and that was dated July 13, 2020, and that included a Powder Run development information. And the same with Girdwood Board of Supervisor meeting minutes, July 20, 2020, and that also included Powder Run development info. And finally, the other attachment is the Girdwood Board of Supervisors conditional use process, and that's labeled as attachment 2. So I think what this does is put us with the issue of, again, looking at whether or not this information was in fact before the Planning and Zoning Commission. And I note that the appellant admits these attachments are not new information in their reply brief. And the variance that's talked about in these was actually divided or decided by a different body. And also note that by putting this in at this time, the appellee really has no chance to respond or address these arguments that are put forth in their reply brief. I think what this does is just there's some disagreement on characterization of efforts to meet community concerns, and I guess that's about what I have to say. Do you have anything to add, Ms. Pease?
No, I think you covered it. We're not dealing with the variance case. The concept of traditional process in Girdwood, the process question wasn't raised earlier. And the assertions or the refutation that there were considerable efforts to make this project compatible, and the refutation that the 3MJ has listened to the concerns of the community. Those were new arguments and subjective arguments that were not raised earlier. So I'm not going to be supporting this motion.
Okay, Mr. Diak.
Yes, Mr. Chair, I do have one. I guess maybe that can go into the findings, but one of the items of the 4 is actually part of the record based on the documents we have on R044, page R044, and that is the variance for the planning action. That is in this document, and unless I'm completely off base, that is part of our documents here, and I do think that is actually admissible in my mind, especially since it was referenced numerous times. Both the appellee and appellant, at that time they were not that, but at the petitioner at the time, referenced the planning action, which allowed a variance for I think it's called Stork Road to be constructed in a certain way, and I think that is part of the record. So I would consider that to be part of the record, even though the addition of it in this case would make it appear that we cannot consider it.
Okay, I guess I look at this a little bit different, because the variance decision is part of the record, and that stands on its own, and that was admitted and considered before the Planning and Zoning Commission. These documents that we're looking at that were submitted now were not before the Planning and Zoning Commission. These particular documents, these attachments, and the P&Z had no opportunity to discuss, and likewise the appellee has no chance to rebut these things. So again, we're looking at very strict rules that we cannot address items that are not in front of the P&Z on record. Now, I know that the variance conclusion and decision by the planning board itself is in the record, but things leading up to that are in these documents or attachments were not before the board. So I do not intend to support this. Any other further discussion? Okay, Madam Clerk, I think we're ready to vote.
Yeah, I'm not quite sure if I just need a little bit more discussion to make sure I understand this. So Mr. Diak is saying that the variance was raised in the deliberations before the Planning and Zoning Commission. And if I understand correctly, Mr. Stewart is saying yes, but the letter of objection, which was part of the variance relief, was not raised. Is that the distinction the two of you are making?
Mr. Diak?
Yes, yes, Ms. Pease, yes. I wanted to make sure that we do know that by acting on this particular motion, we do not ignore the fact that the actual planning case, which was a variance request, and its outcome is part of the record. while the deliberations which then got to that outcome are not. That was the distinctions I wanted to make.
Okay, so Mr. Deak, you will not be supporting this motion. Is that correct?
I will not be supporting this motion.
Okay, thank you.
Okay, what page was that variance on again?
I found it on page 044 of the order and briefs.
I thought I marked
It's
that.
R044. That's the
Oh, okay. Yeah. Right. That's documentation for the record that variance was an action taken and approved by a different body and prior to this particular case being generated. So that's appropriate for us to address because it is part of the record, but the documents, the 4 exhibits that we talked about here in this issue, they were in fact not part of anything in here, even though they may have been considered by the lower body. It's a question of whether or not we can accept items that were not before the planning and zoning as they were presented here. So I do not intend to support this motion. Okay, does that help, Ms. Pease?
Yes, it does. Thank you.
Okay, Madam Clerk, I think we're now ready to vote on this issue.
Mr. Stewart,
No.
Mr. Diak,
no.
Ms. Peace.
No.
That motion fails.
Okay. Again, I plan on coming back to this particular issue to address possible follow-on finding, but that is after we get through more of the other issues. Okay, let's move on to section that deals with issues raised by the appellant. And I think there's they can be encapsulated as 2 issues. One is, did the planning and zoning rely on inaccurate or incomplete evidence in making its decision? And this is kind of an over the top look at everything that was presented by the appellant. And the other issue is, did the P&Z Commission err in deciding the CUP, which is the conditional use permit application, meet the conditions for issuance of the CUP? So I would like to start with the issue that alleges P&Z relied on inaccurate information in the staff report. And that was at record at 007 through R-133, which is the main, that's the crux of the staff report. And the incomplete evidence in making its decision, and that is at the staff report at 008, which states no public comments were received. So can I have a motion putting this issue on the floor?
Yes, Mr. Chair, I'm prepping that. Nancy doesn't seem to interrupt me, so I'll try this one. Okay, I would make a motion to
Maybe
accept.
maybe I can help a little bit.
Yeah, help a little bit.
There's two issues here. One involves the inaccurate and incomplete evidence allegation. And I'm sorry, that's the whole, hang on just a second. I think we've got two parts.
Yeah, so can we do it in two motions? So
well,
I get.
This is the overarching issue that I'm looking at. What I'd like to do is make the motion that the Planning and Zoning Commission did not rely on inaccurate or incomplete evidence in making its decision. This is a positive, but I think this may help us. If we vote on this, it may help us later on. So with that motion being made, rather than put it up for discussion, what I'd like to do is hold off on deciding this issue until we look at the facts. But I need a second first.
Okay, so you did make a motion. I would second that. So that your motion is that the P&Z did not rely on inaccurate or incomplete evidence in making its decision. Is that where we are?
Yes.
Okay, I second that motion.
Was that inaccurate or incomplete? Did I hear both words?
Yes.
Okay.
Now, what I'd like to do is look at this in two parts before we come back and make a decision on this issue, number 4. Part 1 is the appellant alleges staff report at R-008 erroneously referred to adjacent properties to the west of the subject property as GR1 instead of what it should have been was GR2, which led to P&Z erroneous findings for CUP approval standards 2, 6, and 7. And that is in appellant's brief at page 1. So would one of you like to start off this discussion, please?
Go ahead.
What I like to do is just go through the discussion and see what kind of a finding we need to have.
The staff report, I'll start off. So the staff report stated that no public comments were received at the time of the issuance of this report. That is different from what the appellant alleges, which is that no public comments were received. And given that the staff report is written some indeterminate time, but a week or so ahead of the actual meeting, we have no reason to believe that that is the case, that was not, that staff was erroneous in saying no comments had been received at the time of the writing. In addition, and I'm realizing that I need to be able to cite page numbers here. During the
it helps for the record.
Yeah, during the presentation to the commission, staff did note the receipt of public comments, and so I will look for the page at which that was that verbal acknowledgement was made, and then there were acknowledgements of the comments during the discussion.
Mr. Chair.
Yes, Mr. D.
A question. So I understand that you wanted to break it down piece by piece, and I think Ms. P started that with the record, the incomplete record discussion. So are we gonna go with that one, or are we gonna go with the inaccurate data, which is about zoning? Either way, it's fine by me. I just wanted to speak to the zoning first.
We can, no, go ahead and speak to the zoning.
Okay, so the contention is that that inaccurate data was presented to the Planning and Zoning Commission, which was basically inaccurate information about the zoning of adjacent properties. And I do find in the record on page 049 that there is a document which was part of the application, which clearly shows the proper zoning for these parcels. Both the GR2 zoning and the GR1 zoning is properly represented, as well as in the deliberations in the transcript. That discussion did come up several times regarding the zoning of the parcels west of Sprout Road as GR2. So I do believe that that issue is not one which altered the Planning and Zoning Commission's ability to make decisions based on accurate data.
Okay, I'd like to weigh in on this too. I think the report itself, the staff report, it did, as Ms. Pease indicated, improperly designated that property to the west as GR1. But I also note that the zoning map attached to the staff report at R-022 correctly designates the area west of the subject lot as GR2. And this goes to whether or not it was relied upon. Appellee's application shows the correct designation of GR-2 west of the subject lot, and that's at record at 030 and again at 037. And then there's also some evidence of the record that it was referred to or marked as correctly as GR-2 at the record at 060. There's another one at record 061, 086, and 087. And I think it's pretty clear throughout this thing that the staff report, although it incorrectly designated the property to the west as RG1, which is Alyeska Highway Mixed Residential, I see nothing in the transcript that would lead me to believe that P&Z relied on this error in its deliberation. So we've got an error, but I don't think it was relied on. Also note in the appellant's brief at pages 12 and 13, there's references. It's got public documents referenced and one commissioner comments in the transcript regarding this and looking at it as it's a GR-2 district. Just one note that pointed out by our counsel that the appellee references were referring to transcript used in R-031, 35, 39, and 44. And it's clear that that was probably a transcription error because it was referring to the transcript, so it should have been prefaced with a T rather than an R. But at any rate, I don't think there's any question in my mind that the P&Z did not rely on this error. So is there any further discussion before I propose a finding? Okay,
So
I'd
this
like
is-
to propose finding number 6. The staff report at R-008 incorrectly designated surrounding area to the west of the subject property as GR1 Alyeska Highway Mixed Residential. This is just a statement that's wanted to put in there that states that it was in fact an error. So is there any discussion on this proposed finding? Okay, seeing none, hearing none, finding 6 is adopted. The other one is whether it impacted the P&Z decision or whether it was used in their deliberations, and I think we've talked about that at length. I propose finding number 7. The Board of Adjustment finds that the error in the staff report at record R-008 did not factor into the lower body's decision, as there's no evidence that the P&Z relied on this error in its deliberations. And that's kind of wordy, but that's what I'm proposing. Is there any discussion on this one?
I would just add that there's ample evidence elsewhere in the staff report that the correct GR2 zoning was indicated west of the subject property in numerous locations and in discussion.
Mr. Chair, perhaps
Yeah.
perhaps that finding can be amended by adding the actual references to those pages you listed, and I also have added, or at least partially, to show that the record does include the correct statement about the status of zoning of those parcels. But other than that, I do concur that finding will be proper for this particular issue.
Okay. Those sections will be noted in the record itself of our hearing, so those can be cross-referenced if this does get appealed.
Okay.
Any objection to adopting this finding?
No objection.
Okay.
Mr. Chair,
Yes.
Mr. Chair, could I ask you to restate finding number 7?
Finding number 7.
Preliminary finding number 7.
Yeah. The Board of Adjustment finds that the error in the staff report at R-008 did not factor into the lower body's decision, as there is no evidence that P&Z Planning and Zoning Commission relied on this error in its deliberations.
Thank you, Mr. Chair.
Okay, anything else? Council, feel free to weigh in on this if you think that we're missing something or doing something that we should probably address. Okay, let's take a look at part 2. The appellant in their brief filed January 26, 2021 alleges that the staff report at R-008 mistakenly asserted no public comments were received and no Girdwood Board of Supervisor comments were received by P&Z, plus several faxes and letters were not made available to the P&Z, and that's in appellant's brief at page 2. So we need to flush this one out, just like we did on the last one. So would one of you like to start that discussion?
I'll start a discussion, but I will hand this. This is too much, Mr. Chair. I'll start a discussion, but I would refer to Ms. Pease because she has already flushed this out a little bit in the previous go.
Okay.
The at issue is the preparation of the packet does have a delay in terms of the evidence being presented to the commissioners. It does not necessarily mean that that evidence was not presented for the actual hearing. What I did find in the record that the evidence was presented for the hearing, but it was not part of the packet. Ms. Pease, would you like to expand on that?
Yes, the page R-008 of the staff report stated that as of this writing, no responses from the public had been received. So that was sometime prior to the case hearing in August, on August 3rd. We don't know when. However, during the meeting itself, and again, I'm just new at this, so I'm looking for the page numbers. There were references to the comments having been received and delivered to the Planning and Zoning Commission.
Okay. I would also note that the staff noted during the hearing, and this is at T-023, that late comments were received and included in the packet, and that was apparently given to the Planning and Zoning Commission on Friday prior to the hearing. And that's again, that's at T-023. Then subsequently, after the appellant brief was filed, which was filed on January 26th of 2021, the planning staff recognized that it failed to include late comments as part of the official record. And that was submitted to the clerk's office February 1, 2021. That's at the record on 137. And following that, the chair of our board, the Board of Adjustment, issued an order extending the briefing schedule to February 10th. And this gave the appellant the opportunity to submit a revised brief, or they could ask for additional time. And the briefing time that was given to the appellant was submit your brief by February 18th of 2021. I note that the appellant did not submit a revised brief, and I think that the other thing involved here is that by not replying or submitting a revised brief, the appellant, I think, has waived any remaining argument about what public comments were or were not before the P&Z by choosing not to submit its brief after the record was supplemented. So I wanted to get that on the record. Is there any other discussion involving the issue of the public comments not received or other information not received? It looks, yeah, go ahead.
The appellant specifically mentions the Girdwood Board of Supervisors comments, and I think those are, you know, a weighty set of comments. So I just wanted to make sure that we know in the record that the Planning and Zoning Commission did in fact have the Girdwood Board of Supervisors letter. And so I'm not able to turn quickly to the page where that is demonstrated.
Mr. Chairman, if I
Yes.
might, it looks like the public comments, including the Board of Supervisor letter, are in the record at 140 through 157. If you want to take a look there.
Yeah.
So that T or R?
That is R.
Okay, that is the,
Okay.
that's in the supplement number 2.
Yes, so then for our finding here, we would want to reference the fact that the Girdwood Board of Supervisors letter specifically was part of the packet distributed to the Planning and Zoning Commission, and it's at page R 141 and 142. Yeah.
Okay, I know that everything in that supplement 2 was the information that was in the packet given to the P&Z, and that inadvertently was left out, but it was when it was submitted to the clerk. So that was in their record, and we have documentation that it was in the record and was addressed by the Planning and Zoning Commission. Okay. Any further discussion?
Mr. Chair, just one note, and you're gonna have to help me where to land that one. Maybe it comes later, but I would like to call out on the transcript. It is clear that this document, which is referenced as being referenced as missing, no comments. The transcript shows that the actual information has been part of the discussions at the Planning and Zoning Commission hearing, or during that hearing. The transcript, however, does state in numerous occasions, just like pullout 1, T028 is where the actual deliberations reference the document, as the commissioners had no chance to read the document at that time. So I just like to note that the record, narrowly looking at the issue here, the record has been available. So I would state that, but also would state that in the transcript under like this particular page, commissioners reference it as not having sufficient time to look at it, or have not been able to look at it.
What page is that on again?
This happens to be Commissioner Gardner, page T028.
And 29029.
And again, this is not necessarily for this narrow issue which we're talking about, whether it was available. It's the issue about the deliberations. So I'm not sure where to place that, but I just want to bring it up.
Okay, he does indicate, well, regardless, it was in front of that commission.
Yes.
And they were discussing it.
Correct.
Yeah, I mean,
That's for the documentation that the Board of Supervisors letter was there in front of the commission.
Yeah, now to be perfectly upfront, T029 does note, Commissioner Bailey, that she hadn't read the letter by the Board of Supervisors. So there is some disadvantage to having information laid on the table, if that's in fact how it was presented. But it was discussed, and so presumably commissioners were able to come up to speed at the meeting.
I think there was considerable discussion regarding that Girdwood Board of Supervisors objection letter in the transcript. But
Yes.
Again, I think that deals with the internal administration of the Planning and Zoning Commission. We're looking at what is in the record before that Planning and Zoning Commission.
All right, so they had access to the letter, and we're not, then that's our concern.
Yeah. Okay. I'd like to provide the proposed finding number 8, that the staff report dated August 3rd, 2020 was accurate at the time it was written, and public comments, including Girdwood Board of Supervisors letter of objection, were included in the Planning and Zoning packet and considered by the Planning and Zoning Commission during the August 3, 2020 hearing. I know that's a little detailed, but I wanted to make sure that we got that information in there in detail.
That's fine. And could we also then ask that the page numbers that we have referenced be attached as part or included as part of that finding?
I think the page numbers that we're talking about will be in our record. I don't think we have to put them in the finding itself.
All right.
So if the case gets appealed, they can refer to, they'll have the transcript of our commission hearing, our board hearing. Any other suggestions or changes? Any discussion? Okay, seeing none, hearing none, that finding is adopted. I'd like to also make a finding about the potential waiver that we discussed. I'd like to propose finding number 9, appellant Wedeking, I hope I'm pronouncing that right, waived any remaining argument about what public comments were or were not before the Planning and Zoning Commission, having chosen not to resubmit its brief after the record was supplemented. Any discussion?
No discussion.
None.
Okay, seeing and hearing none, this finding is adopted. Now, at this point, what I'd like to do is to go back and address the motion that started all of this, and that is issue number 4.
Issue number 4 on which document before us?
Mr. Chairman, I believe issue 4 is your numbering for purpose of the hearing and not a numbering in the bench.
Correct.
Right. It's in the section in our bench memo. It's in the section under issues raised by appellant. It would be the first. No, it would be number 1 in the issues raised by appellant, but I'm consecutively numbering these issues. So I'm numbering this one as issue number 4. That's what it was made.
Mr. Chair,
Mr.
maybe
Chair.
we can state the motion then and then work from there, because I believe we are at the motion which states that the Planning and Zoning Commission relied on inaccurate or incomplete evidence in making this decision. Is that the one, right?
I think
Mr. Chair, I have the motion as did not rely. So if
Did
that
not, yes.
Okay, thank you.
right. Planning and Zoning Commission did not rely on inaccurate or incomplete evidence in making its decision. That was the motion. I think when looking at our findings, what have we got? We we had findings 6, 7, 8, and 9. And based on our discussion supporting those findings, I intend to support this motion. Mr. Diak. Any
Yes,
comment?
Mr. Chair, again, we tend to make positive motions, but this one will say positively that they did not rely on inaccurate information. And I do concur that our discovery of the record shows that it is correct. So I will also support the motion.
At what point do we consider the information the Planning and Zoning Commission used to decide upon its approval criteria? And I say this because I think there were some areas where the Planning and Zoning Commission may have had incomplete or inaccurate information. There's the discussion of the housing shortage. There also
Okay, we're going to, that's the second part of the, in the bench memo, in the section issues raised by appellant. That's the second part, and we will address that after we vote on issue number 4.
right, but if we vote now that the Planning and Zoning Commission did not rely on inaccurate or incomplete information in making its decision, then how can we raise an issue such as the appellant has raised, which is that there wasn't any documentation about the housing shortage or whether these units were helpful in alleviating housing shortage? That seems to me that that is incomplete, an instance of incomplete information that the appellant has raised. And if we vote now to say that planning and zoning did in fact have accurate and complete information, how can we then come back and say, except for with regard to housing?
Mr.
Or
Chairman,
whatever else
Okay.
may come up.
Mr. Chairman,
Yes,
you could narrow
okay.
narrow this motion to focus on the staff report regarding the zoning and regarding the public comments. So your motion is focused on only those 2 issues, and then Commissioner
That
P's
would-
other issues can come up in the latter part of your discussion.
That would solve my, that would solve
Yeah.
my concern.
Mr. Chairman, I would encourage you to narrow the motion to state exactly as council says, because there are other issues that will come up, and they may become contradictory, and I understand where Mr. Pease is concerned with that. Miss Pease, I do this all the time. Forgive me.
Okay. Mr. Wheeler, where did you suggest we put that in as to amend issue number 4?
I didn't offer specific language, but you could certainly change your main motion to narrow the references however you see fit.
Mr. Chair, if I may, I would offer an amendment to this motion then to try to resolve this issue.
Okay, let's hear the amendment.
So the current motion is the Planning and Zoning Commission did not rely on inaccurate or incomplete evidence in making its decision. I would like to amend that motion that the Planning and Zoning Commission did not rely on inaccurate or incomplete evidence in regards of submitting comments, public comments, and I forgot the other one.
The statement of
The zoning, yes, or the designation of zoning to in making its decision.
Okay, so that would read, after decision, it would be regarding staff report, zoning designations and public comments. I'm sorry, that would go right after evidence. So it would read, the Planning and Zoning Commission did not rely on inaccurate or incomplete evidence regarding the staff report, zoning designations, and public comments in making its decision.
Thank you, Mr. Chair.
Okay, a little rough on the edges, but I think we've got it. Any other discussion? Okay, I intend to support this motion as amended. Anybody else have anything to say before we go to vote?
Nope.
Okay. Madam Clerk, I think we're ready to vote.
Mr. Stewart,
Yes.
Mr. Diak,
Yes.
Ms. Peace.
Yes.
That motion as amended passes.
Okay. The second part on the bench memo is the part that talks about, did the P&Z err in deciding the CUP application met conditions for issuance of the CUP? So what I'd like to do is change that and put it as a statement, and state it as a motion. The P&Z did not err in deciding the conditional use permit application met the conditions for issuance of the conditional use permit. Is there a second?
Yes, Mr. Chair, I would second the motion. So again, the P&Z did not err in deciding. That's how you stated it, right?
Yes. And the
Thank
reason
you.
I did that is I think it may save us from coming back and having to do another finding or. Okay. Again, what I'd like to do on this particular issue, number 5, is I want to hold off deciding this issue until we look at the facts that surround criterias 2, 6, and 7 and address any needed findings. And then we'll come back to this issue and discuss it and make a decision on the motion. Okay. I guess I can start the issue discussion. Well, there's 9 criteria that are listed in the conditional use approval section under AMC 21.03.080D. The appellant has addressed only 3, and that's criteria 2, 6, and 7. And criteria 2 is the proposed use is consistent with the purpose and intent of the zoning district in which it's located including district-specific standards set forth in 2104. And I note that 2104 will refer you to the chapter 21.09 that we use for Girdwood.
Yeah, so
yes.
I have a question here. It seems to me that conditions 2 and conditions 1 are fairly intertwined. The applicant hasn't called out approval criterion number 1, but by inclusion of the Girdwood area plan table 9 and the text, the supporting text, the purpose and intent language, it doesn't seem that we can get around discussing consistency with the comprehensive plan, namely the Girdwood area plan. So are we also obliged, are we obliged, or are we prohibited, or is it optional whether we discuss consistency with criterion 1? Again, the appellant didn't call it out, but the discussion inevitably leads to consistence or inconsistence with the Girdwood area plan.
Well, I think when we go through this and look at condition 2, we may in fact have to take a look at criteria 1 as part of that follow-on discussion.
Okay, that's my feeling as well. I just didn't know whether, because they're intertwined, just didn't know if there was anything that forbade us from looking at criterion 1.
Okay, you know, we're gonna, I think we're discussing part of that, but I think what we're doing is addressing criteria 2. However, it's the staff did assert in the record at R-010 that the Girdwood is experiencing a lack of available housing opportunities for those wishing to relocate to the community. In addition, these housing units will reduce the deficit. So what that looks like is they're saying that there's units relocating and it will reduce the deficit. The same staff assertion was used to support criteria 1, which is compliance with the comprehensive plan, and criteria 2, and that's at the that's in the record at T021 and I'm sorry. Yeah, I think it's 021 and the next page. And then the appellant made the same assertion at the transcript T.026. Now those assertions are maybe supported by the Girdwood area plan at page 29, which indicates availability of housing in Girdwood is limited. And again, at page 32 indicates new population of the growth will create a demand for additional housing. That's part of the Girdwood area plan, and that is available online for those that are listening. The problem is that the Girdwood area plan was adopted in 1995, at least it's that's what's indicated. So It's of the 1995 vintage, and it is or may not be currently accurate. So I'm looking at the Girdwood plan, and it doesn't specifically support the staff assertion that Girdwood is experiencing that lack of available housing. And I also see no supportive evidence in the finding for P&Z finding A.3, and that's at the record in 134 that the CUP would add in reducing the Girdwood shortage of housing. So there's references made to housing shortages, but on the other hand, I don't see anything in there I don't see anything that would support the assertions that are made. And I think it's at this point, it's unclear whether the Planning and Zoning Commission finding is in support of criteria 1, criteria 2, or whether it supports both. But I see nothing in the record of any currently accurate evidence beyond mere assertions.
Yeah,
Ms. Pease.
Yeah, I agree with you on that the record does not seem to have any data or any analysis regarding the lack of housing, or whether these units would aid in reducing the specific lack of housing that might be that there might currently be. So that's an area where we may feel the commission made a finding without foundational evidence, without documentation. And again, this is because I'm new. So if we find that finding was unfounded, then how do we tie that into the commission's findings that approval criteria 1 and 2 how do we tie it into their approval of criteria 1 and 2? I guess what I'm asking is, do we first make a finding that the commission's finding of fact A3 regarding housing is without documented evidence? Is that what we do? And then do we discuss whether without that evidence they can correctly make an assertion about 1 and 2?
That's what I'd like to do.
Okay.
So I would propose that we find, would be finding number 10.
Okay.
The Board of Adjustment finds P&Z finding A.3 is not supported by substantial evidence in the record. And that's the criteria. If there has to be substantial in the information or evidence in the record to support.
Mr. Chair, I would concur with that brief and clear statement. That's exactly what I think the crux of this topic is. Whether the petitioner provided proof to make the case for this housing issue to become a driving force for this project to receive a conditional use application or permit. And I wanted to say that doing this over and over, I always read the last paragraph of the application page, which is also part of our record, which always states that the burden of proof is on the petitioner to make sure that the case can be approved. And this is a conditional use application. on land which does have by right uses allowable, and what is now in front of the Planning and Zoning Commission as a conditional use permit case. And in that case packet, I concur that this finding is accurate, that we do not have any information about the housing shortage, which then is referenced in the findings.
Okay. Any other discussion before involving finding number 10?
It's 10, right? Okay.
Okay. Any objections to finding number 10? Okay. Finding number 10 is adopted. And what this does, it puts us in a situation where we may have to remove, or we have to handle, how do we change, or what we do with the P&Z resolution involving that finding. So there's a way to do that, and that is for the board to substitute its independent judgment. And we could remove finding A.3 from the P&Z findings, and we could do that with a motion or a finding, but I would like to hear from council whether that is something that can be handled with a finding, or whether we should do a motion. Mr. Wheeler.
Yes, Mr. Chairman, the code requires that you have a unanimous vote on this issue, so I suggest you just go ahead and do a motion and catalog the vote.
Okay.
Mr. Chair, may I ask another procedural question before we move on then?
Yes.
Yeah, so thank you. So just to understand the process, so our options are we render independent judgment, but I believe also there was options which then asserting this issue in other ways, and I would like council to help us. I think there was the idea of remand, or there was some other options. If we could hear a brief on that one.
Mr. Chairman, Mr. Diak, yeah, so the next step is probably the hardest part of this entire case, and that is, what do you do with this discussion about the need for housing if it's not part of the P&Z findings, because you've determined that based on your independent judgment there's not support for that in the record. The question is, does a conditional use permit need to solve a housing issue in order to be approved? If the housing issue is not a criteria for the CUP, what do you do with that situation? And I think we can have a further discussion about that. If it's not a required underpinning for the CUP, the fact that the finding was not supported may not ultimately sway you one way or another as to whether the criteria were met.
Thank you.
Okay, Mr. Wheeler, do you think it'd be more appropriate to put the motion in now, or would it be something that we would put closer to the end and possibly use as part of the conclusions?
I think you can make the initial decision now as to whether or not you think the finding was supported, and then move on from there.
Okay, and there's another possibility, and that would be to not remove the entire A.3 finding, but to amend it and take out the part that deals with the housing shortage, but I think if we do that, it really doesn't handle the issue. The finding itself is talking about 9 units that will resolve or help resolve the housing shortage. So it's intertwined. So I'd like to make the motion and just we remove 8.3 from the P&Z findings. So I'm ready to make that motion if there are no other discussions.
Sounds good.
Okay. Hang on just a second. Okay, this would be motion number 6. Motion number 6. Board of Adjustment substitutes its own independent judgment for that of the Planning and Zoning Commission and change the resolution by deleting finding of fact A.3 by striking through A.3 and renumbering the remaining findings. So I've added a little bit of procedure in here at the same time. I'd like to keep it apparent what we've done when we get down into putting our record together, but it also be straightforward on what we're looking at.
Mr. Chair, I would second that, and thanks for your justification as well.
Ms. Pease, any discussion?
No.
Okay, I intend to support this motion. Madam Clerk, I think we're ready to vote.
Mr. Stewart,
Yes.
Mr. Diak,
Yes.
Ms. Peace,
Yes.
that motion passes.
Okay, the motion is approved by 3 in favor, 0 not in favor. It's a unanimous. Okay. What this really does now is it forces us to kind of take a look at criteria 1 and criteria 2 because we're not sure what the impact is going to be. So I'd like to have some discussion on criteria 1 and criteria 2, starting with criteria 1.
Mr. Chair, with this, before we launch into that, could we have a 3-minute break?
Yes, let's take a 5-minute break, and we'll be in recess for 5 minutes.
Thank you.
It's 11:55, right?
Yeah, it's 11:50 right now. Let's try to get back together at 11:55.
Sounds
Thank
good.
you.
Right, Mr. Chair, I'll stop the recording, and everyone that's in the meeting, of course, is welcome to stay, and we will restart the recording after the break.
Okay.
Okay, looks like you're recording again.
Okay. The Board of Adjustment meeting is resumed after a 5-minute recess. We're back on the record. On criteria 1, I think what we're looking at now is whether the proposed use is consistent with criteria 1. And criteria 1 is the comprehensive plan and applicable provisions of the title, etc., in light of our change to the planning and zoning resolution where we deleted finding 8.3. So this is, as the council indicated, this is a little bit more complicated. So, Mr. Deek, would you like to take a stab at starting the discussion?
Yeah, I would love to, Mr. Chair. Thank you very much. The first, there are 9 conditions which a petition is to meet to receive a conditional use permit. The first one is about consistency with the comprehensive plan and applicable provisions of this title, meaning Title 21, and applicable state and federal regulations. With the discussions we had just prior, it appears that we're going to have to address both 1 and 2 in some fashion. So I would start with this issue of the comprehensive plan. As we have stated, we do consider the Girdwood area plan as part of the record, since that is part of the comprehensive plan of the municipality. And in that document, we have a few items called out, and actually I think some of them were added as attachments by the appellant, and also as a part of the document, which I think would be valuable to look at. One aspect of this is the land use plan map, which is on in Chapter 7. It's map 11. And that document, I believe, is referenced in the packet, but I do not believe that there was a real picture of it in here. So I'm gonna have to see if that's the case. Why I'm bringing that up is because that's the document which shows this area, the lower Girdwood area, as primarily single-family residential in its status. This whole area is basically labeled as that. And then the table 9, which is page 49 of the Girdwood area plan, which was part of our discussion earlier, and it's part of the record, is talking about planning for the growth of Girdwood, and assigning some numbers to various areas of Girdwood. And I think we want to look at table 9, talking about housing densities and residential development guidelines, because it's clearly looking at some growth, but it's clearly also assigning growth in various parts of Girdwood, as most planning documents would do. So if you look at residential single family, the densities are set at 2 to 4. And then there is a statement there for lots fronting Alyeska Highway west of Glacier Creek. There is densities at 2 to 8, 5 to 8 dwelling units per acre, or triplexes or greater structures require conditional use. That's already in this planning document, which then was later became later part of the land use code, on which this application relies on, because the conditional use application was exactly for addressing this issue. And the one comment or concern I would bring up is that this particular parcel is fronting the Alyeska Highway. It has received a different designation, which is the residential one, Girdwood residential 1 designation, while the surrounding lots to the west remained Girdwood residential 2. And the one big issue in the record, which we will look at later in the other topics, is that the original plan, which is right now in our records as R043 on that page, show the land division of this area, and we can look at this and see that the land area as shown definitely looks at the Girdwood Alaska Highway as access. And I would like to have the discussion about how access to a parcel and the densities relate to each other in defining what is appropriate for a conditional use. And I think the appellant also has raised this question and also did testimonies which are in our transcript. So this is opening up this whole issue about housing shortage and weighing that, or the potential housing shortage, and weighing that to the planning documents, which then look at areas based on their existing conditions and future growth scenarios.
I will chime in that I had the same kind of reaction maybe to the table 9, and wanted to just raise the technical question, whether fronting, it says lots fronting Alaska Highway is different from frontage, and maybe this doesn't apply, but is there a legal distinction between frontage and fronting? Because if there is, would that mean that a lot developed for these uses would need to be diverting, or for these more intense uses would need to be directing that intensity toward the highway? And trying to figure that out, I looked at Title 2106-030C, which deals with frontage of corner lots and double front lots, and it doesn't offer a lot of guidance. It says the property owner, with the concurrence of the traffic engineer, has discretion on which frontage shall be the primary front setback. So it sounds as if access, driveway access, is a consideration in determining whether a lot's fronting on one road or the other. I don't know if this matters, but anyway, that's my. I
think if I remember right, in the definitions, there is that kind of distinction between frontage and what was the other term you used?
Fronting. Fronting is what's used in the Girdwood Area Plan. I couldn't find a definition for frontage versus fronting in Title 21.
Mr. Deek.
Yes.
Were you going to say something?
Yeah, I would like to, and that is that that I think this is why, based on our focus on the appeal, we have an issue here which we either gonna venture into acting as the Planning and Zoning Commission, or we're gonna have to decide in what fashion this issue can be addressed. And I'm not sure if I know the answer to that at this point, but I do know that that this whole issue about housing also has a parallel consideration in terms of what is the housing, where it happens, and whether it is appropriately addressing its context. And in this particular issue, based on the original plat and based on the documents which we have reviewed, it seems like that we have a project where this frontage is becoming an issue, and that's what we heard from these comments in the written transcript. Again, I do not know yet what the process is to address this, but I would definitely want to make sure that we do discuss it and bring it on the table, or put it on the table, because I think that's one of the most crucial elements of this appeal, as reading the three conditions which were challenged. And I do think that, again, in a conditional use permit application, we have to consider, or the Planning and Zoning Commission has to consider, all of the factual evidence to make sure that they make the decision as they intend to in the end. And I've seen several references to the Girdwood area plan as outdated. At the same time, the Girdwood area plan has been very much not outdated when it seemed like to support the goals of either the petitioner or of the appellant. And I think that issue has to be addressed by the Planning and Zoning Commission so they can make proper findings on why they act in a certain way. And that's one of the concerns with condition number one, the standard number one.
So, Mr. Diak, are you asking whether we have a finding on the currency, the up to the current accuracy of the Girdwood area plan for today's conditions? Is that kind of what you're getting at?
I'm getting at that because again, many times what was brought up in the record, and when I say many times, I can look it up, but I'm gonna have to dig in again because my notes are like that, with flipping pages left and right. But you probably know the reference about access to Alyeska Highway was brought up both by the petitioner and staff, and also the members of the public. And the Girdwood area plan has no statement on the state of Alaska Department of Transportation's changed approach to allowing access to Alyeska Highway. While that simple fact does totally change the way how you can develop parcels in this area. And I think that needs some examination. And that can be an issue which then supports a higher density at a different location being the access or not. And I think that has, to me, it does not clearly come out from the record that was discussed in depth, which I think it requires.
Well, I think I agree. I think I agree with you. I think if what you're saying is different from what I'm about to say, then we can figure that out. But I was troubled that there were numerous assertions by the 3MJ and by staff that access to Alyeska Highway would not be allowed by the Department of Transportation. Also that access to Gunnysack Road would not be practical or feasible. I don't know what words were used. And there wasn't any documentary evidence for either one. I was looking for some kind of a project review or a letter of refusal from DOT. There wasn't any. There were references to a refusal for access for an adjoining property. That wasn't provided as part of the record. So that was, I don't know if that's what you were saying, but I didn't see any conclusive evidence in the record as to whether access to Alyeska Highway or Gunnysack Road is what in fact denied or is in fact impossible or impractical.
Well, I think that was addressed in the, I think it was addressed in the transcript. I'm not sure exactly what page, but the lot that is directly north of the subject lot that we're working on, that something occurred where there was a prohibition put into that particular lot's legal description that noted there access to Alyeska Highway from that lot was not approved or
right.
Something like
stated,
that.
But it wasn't documented, and I don't know whether for our purposes of finding a really solid record, whether the planning, more particularly, whether the Planning and Zoning Commission should have required documentation. I mean, normally when an agency denies something, you get it in writing, and there wasn't anything submitted that I could see. There was applicant testimony, but not any documentation.
Well, I think the testimony goes to the applicability of what kind of units are going to fit into this community. And I think that that particular lot to the north was not the subject of the discussion or a subject of the meeting, but it was brought in to show, I think, here's what the general development in the area is like, and it will affect some of the actions taken will affect how the planning and zoning looks at the particular ability of these dwelling units to fit into the general area, to see if they will actually fit under the conditional use. I would like to address that the Girdwood area plan. I think at the staff report at R-009 notes that the 1995 Girdwood area plan is intended to guide development in the area. And the land use map at page 69 of the plan designates the area as single family residential. So that indicates to me that the Girdwood area plan 1995 is what's intended to serve as a guide to help development in that area. But I also know that in Anchorage Municipal Code 21.01.080, and this kind of goes through the conditional uses shall be consistent with the comprehensive plan in D3. And D4, conditional uses shall conform to the land use map plan and other applicable plans in the elements in table 21.01-1. The Girdwood area plan is identified in there in table 21.01-1. But if you look at D5 of that same section of the code, when the comprehensive plan elements conflict, the most recently adopted shall govern. And to me, what that means is the Girdwood plan is still there as a guide, but the Anchorage Ordinance 2005-81, the S version that was adopted by the Planning and Zoning and Assembly, the Anchorage Assembly in 2005, that in fact takes priority, and it created GR1 and GR2 for that area. So that comes into the mix. So at this point, the discussion about what access is given, I think will probably come up if we look at 2 and 7. Two, 6, and 7. Actually, it'd probably be a discussion that we should look at under criteria 6, because it looks at compatible uses with allowed on adjacent properties.
Yeah, or 7, because the routing of the traffic is a way to reduce significant.
Yeah, that addresses. There's where we should be discussing what happens with Gunnysack, Alyeska Highway, and the Sproat. I guess it's Sproat Road.
So
Not sure if I'm pronouncing it right.
So if I understand the chair's saying that the access to the highway is to be considered in terms of mitigation, and you feel, I'm paraphrasing, you feel that access to the highway is not to be considered here because it is not how we determine whether a lot fronts on the highway, and that's not a concern? Is that, I guess, getting back to my concern, the Girdwood area plan says that multifamily will take place on lots fronting Alyeska Highway west of Glacier Creek. And I guess I just want to make sure that there's this lot
Okay.
is fronting on Alyeska Highway, not just that it has frontage, but that it's fronting if it's developed with a road access away from Alyeska Highway. Is that a problem?
I think that should be addressed later. But I don't think it's a whether it's in the whether it's consistent with the comprehensive plan as it's stated. I think in this case, we're just looking at the overview. We're not looking at the direct content. So we're looking at the number of housing units that are allowed in GR1 compared to housing units that were envisioned in the Girdwood area plan, which now is governed, that decision now is governed by the zoning districts that were approved through the Anchorage Ordinance 2005-81S in 2005 by the Assembly.
Yeah, there's
So-
there's no difference in the number of units allowed when you look at the zoning, the 2005 zoning versus the 1995 Girdwood area plan. There's no discrepancy in the number of units. I guess my question is whether it's this particular lot, which has frontage on Alyeska Highway, but because of its access concerns, could be interpreted as fronting on Sproat Road. Does that create a problem? So it's not the number of units, it's whether this lot falls under the category for the
Well, I think there's all the lots that are adjacent to Alyeska Highway actually front the Alyeska Highway.
Yeah.
But where you decide to put the entrance to the lot itself determines the frontage of that lot.
Mr. Chair, if I may, maybe perhaps this is the time, if it's still, we started out with condition 2. We made our motion, we approved it. And now we are looking at 1 and 2. And the reason why we're looking at that, because it broadened the scope here a little bit. And I do think that a finding which puts the documents in some logical context would be helpful. And I think the finding is that the Girdwood area plan, which is the adopted document for part of the comprehensive plan, does describe the planning goals on those pages 48, 49, and it's a land use map or land use plan, which then were furthered as becoming code in 2005 and becoming the districts which we refer to as GR1 and GR2. Those are, in my view, not at all contradictory. I think that's basically when planning documents become code, and then the execution of these, though, whether the intent of the original planning intent, which was a lot fronting the Alyeska Highway, will be allowed to look at larger densities or even different types of residential uses, like I think they listed hotels and inns, multiple family housing, whether that has been decoupled by us not looking at the map in a way that the intent is that these properties will be useful for those uses if other conditions exist. That's my contention on that one. Because if we just simply state that we're gonna completely separate each of the issues and don't look at the context of this planning intent, then you do get into this issue of whether the conditions are met, and 6 and 7 clearly are two conditions which were contested for this specific reasons, which is traffic and impact on neighboring properties.
Okay, I'd like to ask council to weigh in on this and help us with this. What, do you have any input, Mr. Wheeler?
I would I would recommend you back up just a little bit here. I agree with Mr. Diak that it might be appropriate to recognize that the Girdwood area plan is still the officially adopted and applicable plan of the municipality in this area, and that plan has been at least partially implemented by the AO 2005-81S, and that code is at least presumptively in compliance with the plan because there's been no known challenge to the adoption of that code as it applies to the plan. You know, those code changes need to be consistent with the plan, and there's not an issue in front of us regarding that. So work from there, right? So start with that, and then if you want to talk about whether or not, for example, access is an issue, then you need to identify where in either the code or the plan access is addressed in that fashion, and work and deal with that, and then we'll move on.
Okay, I think we've already made a finding in the record that the Girdwood area plan was adopted and is part of the Anchorage Municipal Code. So what you're saying is we should acknowledge that again and then refer to the change as a partial implementation.
You mean the zoning as a partial implementation?
Yeah.
Yes. Yes.
Yeah. Mr. Chair, I would like to offer that finding would put it on the proceedings of this body, and I think it would be useful to have it in our records, and basically stating that the governing planning document is the Girdwood area plan, which then have been gone through implementation by adopting the Title 21 Girdwood section, which is 2109, and I think that's a good start for stating the basics, because all the discussion basically stems from this process.
Okay. Madam Clerk, can you read that back to us?
I don't think I can, Mr. Chair.
Yeah.
I think I'll need you to restate it, Mr. Diak.
Yeah. So if I'm the one who's making the statement, then let's try this. So the finding, I think number 11 would be that the Board of Adjustments finds that the governing planning document for this area is the Girdwood area plan, which has been I guess the word is
At least partially implemented?
Implemented, I think, is the word. Has been partially implemented by the adoption of the zoning regulations for Girdwood in Title 21, and the ordinance number is 2005 something. I don't know the exact quote.
AO
And then
2005.
81S.
Right.
Thank you, Mr. Diak.
Okay. I'm in agreement with that, except for the part where we find that this is the finds the Girdwood area plan as the governing document.
No, it's the guiding planning document.
Okay. Because the governing document itself is the Alaska Administrative Code, and that's been it actually takes precedence because it's the most recently adopted. And I agree that the Girdwood area plan is in fact intended as a guide, and that's set forth in the staff report.
Mr. Chair, again, just a clarification on that thought process. What I think this finding should present is that there is no, we do not sunset the guiding planning document just because we implement parts of it by writing code, which then becomes part of the municipal code. So stating that the guiding document is the planning document, which is a Girdwood area plan, which has been implemented by adopting the zoning regulations for this area, is describing the proper planning process, how we develop land. And I think that statement should be there because I have the feeling that sometimes we decide that one of them doesn't apply any longer, and I do not think that's the case.
Mr. Chairman.
Yes, Mr. Wheeler.
Yeah, you mentioned Alaska Administrative Code, but I think you meant to reference Title 21. But let me just echo what Mr. Diak is saying. Under a code section that you cited earlier, 2101-080 regarding comprehensive plans, D3 indicates that amendments to the title, rezones, conditional uses, subdivisions, and other related discretionary actions shall be consistent with the comp plan, including its goals, objectives, policies, and strategies. So in the work that I've done for the city, I've always taken the position that the comp plan is your primary and guiding document. Code changes need to be in conformance with that plan. What I've said here is that the code changes, i.e. Title 21, Chapter 9, are including the ordinance I referenced that was passed in 2005, are presumptively at this point in conformance and consistent with the plan.
And there's been no challenge on it, right?
That's correct. So one of the issues here is how the plan in 95 speaks to single family housing, but the implementing ordinances allow multifamily housing, right? You might say that appears to be a potential area of conflict, but I would argue that through the adoption of that implementing document back in 2005, that has become the status quo, and it's unchallenged, and it's not in front of this body to debate whether that 2005 ordinance is or isn't consistent with the plan. It presumptively is for purposes of this case.
I mean, we can go one step further. The Girdwood area plan, actually, it says in Table 9, single family, duplex, and multifamily are part of the quote unquote residential land use classification for lots fronting Alaska Highway. So there's no, I don't think there's any inconsistency at all between the fact that multifamily can be built along the Alyeska Highway in the plan versus in the zoning 2109, unless there's an issue with whether it has to front on the highway, whether lots have to front on the highway, or whether they can front on adjoining roads.
I don't see anything in the record or in the law that indicates that the Girdwood area plan when it was passed or how it's being implemented indicates that everything that fronts Alyeska Highway must have access from lots onto Alyeska Highway. I think that is part of the conditional use process.
It is.
Okay.
It is, but what I would say, Mr. Chair, is that we have to look at intent, and I think at least to me it's clear based on how the zoning districts were established that the intent was that you have a different land use classification along the Alyeska Highway, that's GR1, then west of it, which is GR2. That's a clear indication of intent. They do not, or the writers of the code did not assume that that whole area, which in the land use plan is shown as yellow single family, will be subject to any kind of conditional use process where you have multiple family units or a higher density even considered, which then tells me that that the intent is that along the major thoroughfare is where the higher density is intended. So there is a correlation. And again, as far as the record goes, as you stated, I do believe that intent is part of a discussion area where we have to make sure that we have proper findings. That's why I thought that stating that the guiding document is the Girdwood area plan with the implementation of it being the code, Title 21, is a proper statement on our part to make sure that those documents do not contradict each other necessarily, but they have to work in hand in hand in implementation and expressing intent.
Okay. With that, is there any more discussion on finding number 11? Okay. Finding number 11, seeing none and hearing none, no objections. Finding number 11 is adopted.
Mr. Chair, I'm going to turn my camera off. I'll still have my microphone on. I need to get a charger for my iPad.
Okay.
So I can continue. But I'm still on the call.
But the other thing that I'd like to address in here is the actual effect on criteria 1. It looks like taking away that information regarding housing shortage does not affect criteria 1. And I'd like to put that in a motion for consideration here. Oh, I'm sorry, I just want to do a finding.
Would you like to state that, Mr. Chair, how you see that language?
Okay, I think it's very simple. I'd like to have a finding, let me call this number, this would be number 12. There is no substantial evidence to support P&Z's conclusion that criteria 1 is met. I'm sorry, did I say no? I said there is. I meant to say
there is no.
There is substantial evidence to support P&Z's conclusion that criteria 1 is met. Any discussion?
None from me.
Okay. That finding number 12 is adopted.
I don't know if Nancy's back, Mr. Chair, if I may, let's just have her the ability to perhaps, I don't know if you, I don't see her
I'm
yet.
here. Yeah, no,
Okay.
I'm here. I'm still trying to position my iPad, but I'm listening.
Yeah, she's listening.
Yeah. Well, the one concern I have stated, and I guess I haven't totally resolved in my mind, is whether the language in the Girdwood Area Plan Table 9 with regard to lots fronting is fronting and frontage are interchangeable. I just need to clarify that the term fronting on Alyeska Highway is not a problem. And I guess what I heard Mr. Stewart say is that, oh yeah, I just, since I'm not a legal person, I just would like, I guess I'd like maybe Mr. Wheeler to say that fronting and frontage are the same thing or something to that effect, so that this lot, if it's proposed to have access and therefore front on Sproat Road, still falls under the category of fronting on Alyeska Highway.
Mr. Chairman, Ms. Pease, I'm looking at table 9. This is on page 49 of the Girdwood Area Plan. I'm looking for the words frontage or front that you're referring to.
It's the left-hand side of the table below single family.
It's under residential single family for lots fronting Alyeska Highway west of Glacier Creek.
Oh, there it is. I see it. Sorry, I was looking on the right side for some reason. It's on the left. Sorry about that. Yeah. So I would think for purposes of the plan, fronting is lots that are adjoining to the highway right of way. It doesn't necessarily mean that's considered the front of the lot for other purposes, but certainly those lots that are adjacent to, and there's a code reference to frontage in the code. Let me see if I can pull that up real quick. I had it earlier. Just give me a second here.
Well, in 21.
And the code, and for purposes of the plan, this code definition isn't necessarily the driver per se, but let me just, for comparison purposes, pull it up. So frontage under the definitions in Title 21, this is 21-15-040, frontage, the edge of something, usually a lot, building, or parking lot that abuts a street. So I don't think there's any particular debate that the property at issue fronts the highway for purposes of the plan.
All right, that's what I was looking for, and I couldn't find that definition. So if this lot is in fact fronting on the highway, and therefore the Girdwood Area Plan calls it out for multifamily with the 2 to 8 density, it seems like that's right in line with the zoning. And so I would say that I have I'm in concurrence that criterion 1 of the of the conditional use criterion 1 is met.
Okay, so then I'd like to reiterate that finding number 12 is adopted. So let's take a look at criteria 2 to see if that is still consistent with the purpose and intent of the district specific standards. We have taken out the issue of housing shortage, but the appellant is challenging issue 2 or criteria 2. So Ms. Pease, would you like to start this one? Or, all right, I can go ahead and discuss this one and make it a little bit easier.
Yep. What?
Appellant is just talking about, hang on just a second.
Yeah, if we don't have to do a motion, I can sort of wade into it. The appellant says that there's no evidence about a housing shortage, but the zoning district itself doesn't. No, go ahead. I'm needing to look at the zoning district language again. I don't have that right in front of me.
Okay, I'm going to take a look at the okay, it was under 2, the proposed use is consistent with the purpose and intent of the zoning district in which it's located, including district specific standards set forth in 2104. The appellant is saying that there's wait a minute, let's see there.
Well, I now have in front of me the intent of the GR1 district, which is to continue the existing pattern of development as dwelling units are constructed on the remaining undeveloped lots, and to permit development of hostels, inns, and multifamily housing. So the intent is not just to continue the existing pattern, it's also to alter the existing pattern by permitting, in this case, multifamily housing. And the proposed development is within the intent as clearly stated. It doesn't, the zoning district doesn't say anything about alleviating a housing shortage. I guess the question is, in fact, a conditional use doesn't have to demonstrate, anywhere that I could see, it doesn't have to demonstrate that it delivers a certain public good. The criterion seem more aiming at mitigating any potential impacts. So there's no criterion that the housing must be to alleviate a housing shortage. And the zoning district clearly says multifamily housing.
Well, I think it's a little difficult to figure out exactly what the appellant was using as a basis to question criteria number 2, because I think they were talking about maybe the price of the condominiums as not being consistent with the purpose and intent. And there was also an issue that even if they said, even if you alleviate the housing shortage, he said the granting the conditional use permit failing to require owner occupancy is inconsistent with that reasoning. So it's, I think what we have to do is just look at criteria 2 and what the what the appellant is trying to say. But it appears that the appellant did not identify any specific standards that were unmet by the applicant, as didn't address any of the conditions that were provided by P&Z.
So I guess I maybe made a mistake in not bringing this up under criterion 1. The question of affordability is covered in the Girdwood Area Plan.
Okay, but it's not,
on page 48.
Yeah, but it's not part of the conditional use requirements.
Mr. Chair, I will be in line to have some comments when you or Ms.
Okay,
Pease
go ahead.
are done. Should I go ahead now, Nancy?
Sure.
So I think condition number 2, the appellant is using appears to use the justifications which were given by the petitioner and then included into the staff recommendations. If you just look at R010 under the staff recommendations, their justification of this project meeting the conditions in their review clearly states that Girdwood is currently experiencing a lack of the discussion we had earlier. So Girdwood is currently experiencing a lack of available housing opportunities for those wishing to relocate to this community. And then goes on further, the addition of these housing units will help reduce this deficit. Additionally, this use is consistent with the intent of the underlying zoning district and its district-specific standards. So I think what the appellant was discussing that the basis on which this statement or this condition is met is heavily relying on this issue of housing need versus what other justifications there may be, and that's what's being challenged. And we have already discovered that that particular statement has not been substantiated by evidence. So what we are looking at now is whether the purpose and intent of the zoning district is truly consistent with this use. And a question I have is that is it our task to make that determination, or is it our task to call out that that particular justification simply has not been provided, or it's maybe spotty? There is a statement, again, the last sentence in the staff justification, but if you look at the actual conditions, and hopefully I'm gonna find it here. Just give me a second. So this is in the findings of the again, page 10 of R010. This is of the findings of the case, and it's part of the record for the appeal, and it does state the district specifics on R11. It does state that the standards for the GR1 allow for the placement of more than one structure on a lot, subject to the approval of an administrative site plan review. This conditional use request supersedes that requirement. So they are referencing the actual process of the conditional use to make sure that these issues are vetted. I don't think there was any statement on this project not meeting the condition of being consistent with the purpose of the zoning district, or the purpose and intent of the zoning district. Is the appellant is stating though that their justification and findings do not support that finding. I think that's the issue.
Yeah, I actually think there's another issue here, which is that even though the appellant has objected to condition 2, he's actually referencing the Girdwood area plan's intent for affordable housing available, so presumably in the price range of seasonal and full-time residents in the community. And that's language from the Girdwood area plan. And so really we're back to condition of approval 1.
I think the criteria 2 really deals with what kind of pattern is going to be allowed in this, in GR1. And I don't think, see, we've already discovered that the affordable housing and the number of homes available, or the shortage, that was not supported. But affordable housing is really not part of the criteria.
It's not part of criterion 2, but it is part of criterion 1. And so we should have looked at this particular assertion when we voted on criterion 1. I was fixated on table 9 and not looking at this language on pages 48 and 49. And so I'm not sure that that if the affordability part of the Girdwood area plan, and affordability apparently being defined as within the price range of seasonal full-time residents in the community, if that's part of what brings this project into conformity with the plan, we don't have any evidence. No evidence was presented on affordability. Therefore, how can we make a determination that this proposed project is affordable and therefore is in conformance with the Girdwood area plan intent for the lots fronting the highway? The multifamily housing.
I think the intent, we have to look at the GR1.
Right, but the GR1 doesn't talk about affordability. GR1 just talks about multifamily. So we know that's all right. That's in conformance. But then looking at the reason for, multifamily in the Girdwood area plan, it's intended to be affordable and available to both seasonal and full-time residents of the community.
So, Mr. Chair, perhaps I think I'm understanding where Ms. Pease is going with this, because it's similar to the first finding, which was, I think, 11, in that we are looking at the issue of number 2, condition number 2, and that is indeed talking about the proposed use is consistent with the purpose and intent of the zoning district. I think there is no argument that a multi-family proposal is allowed in this zoning district under the conditions which it lists. But what is probably truly again maybe require a finding for condition 1 is this issue whether the Girdwood area plan is implemented by producing these affordable units, because the intent is for that density to increase to enable developers to do that. And maybe a statement on that or a findings on that could help, because in itself, I think condition number 2 is definitely something which we can find in code. It doesn't seem like it's inconsistent.
Mr. Wheeler, would you like to weigh in on this?
I think I would suggest, as I think Mr. Diak was suggesting, that you finish number 2, and if you want to go back to the number 1 issue, you can. But let's try to keep it somewhat compartmentalized to the extent you can, so you're not spinning in circles.
Okay, so wanted to go back and look at criteria 2. Where's conditional use?
So I guess if I hear Mr. Wheeler correctly, face of it, the applicant, the proposal seems, the multifamily housing seems consistent with criterion 2, but I know we already voted on it, but the applicant's application's a little bit disjoint, and this particular concern derives from criterion 1, and I would want to revisit my concurrence. I'm not sure it does comply with provision 1 or criterion 1.
Well, we can hold that and go back and relook criteria 1, but let's finish up with this one, I think.
Okay.
So the criteria 2 is the proposed use is consistent with the purpose and intent of the zoning district in which it's located. And it's located in GR1. And the intent of this district is to continue the existing pattern of dwelling units as dwelling units are constructed on the remaining undeveloped lots, and to permit hostels, inns, and multiple housing development. So that's what we're looking at for this one. I think the question here is there substantial evidence in the record now that we've taken out A.3, and is there substantial evidence in the record to support planning and zoning's finding that the additional, well, no, we took that out. No, we didn't. That the additional addition of 4 units above what is allowed by right is appropriate in this particular case. I think that's what we're looking at.
I think it's even simpler than that. I think multifamily housing is what we're looking at, not the number of units. I think comes in when we talk about criterion 6 and 7. That's the intensity. This is because the multifamily housing is, yeah, it's allowed. How many multifamily units? That I think falls under
compatibility. We're looking at how the area is being developed, and we've already looked at what can go in there. And by right, there's 5 units that can be put into this particular lot, and under conditional use, it could go to 12. They have added. They went to 9 total. So in essence, what that does is that does this substantially impact the development in that area and send it in a different way? Does it go to the high density housing that's up near the recreation area where the lift is at, or is this compatible? Is it appropriate for this particular area? So it's a difference of whether or not the extra 4 units put on this acreage is appropriate and still stays within the existing pattern of development.
Mr. Chair,
Yes.
I think under condition 2, that question is not, in my view at least, it's not the crux of the question. The proof is about whether the development is applicable in the zoning district based on intent and what the zoning district allowed and allows. And that I think that is undeniable that a multifamily housing development in a zoning district that does allow it is consistent. I think the issues which we're talking about density and access and all those perhaps come in under the other conditions, and also the larger question about affordability that would come in under the first question, first standard.
I agree with Mr. Dayak. This is pretty clear cut and pretty narrow. Multifamily housing is allowed in this district, and this is a multifamily proposal. And then we get to affordability through talking about criterion 1 and the Girdwood Area Plan, and we get to density when we talk about criteria 6 and 7. So I fully feel that criterion 2 is met, and it's a simple, narrow issue in this case.
Okay, I agree that there's substantial evidence in the record to support the proposed use as it's conditioned by P&Z. So what I'd like to do is put a finding in here. This would be finding number 13. The proposed use as conditioned by Planning and Zoning Commission meets criteria 2. And that's what we're talking about. Does that meet with your approval?
Well, I don't know why we need to put the conditions in there, because we may have I may have some differences with their conditions. We may find we have differences with their conditions. So I would just drop that reference to the P&Z conditions.
Well, the conditions, I'm sorry, what I meant by conditioned is the planning and zoning resolution. They made findings and they added conditions. It's all part of the resolution. Now, if we later on find that these conditions are inappropriate or something needs to be changed, then we can address that. But so far as the purpose for intent in meeting the standards in criteria 2, the conditions that are put in, we're looking at the whole resolution.
Yes.
Taken out 8.3.
Yes.
So does the rest of that, does the resolution by planning and zoning meet criteria 2? That's what we're talking about.
Correct. And Mr. Chair, if I may, the findings 8.2 does simply state what we just talked about.
Yes.
The request is consistent with the purpose and intent of parcel's underlying zoning designation. That's already in there. So so I think a simple statement on the finding is that criteria number 2 is found to be supported by the evidence in the record. That probably would be as simple as that.
Okay, so you would amend the finding to say the proposed use as conditioned by the planning and zoning meets criteria 2. And is supported by substantial evidence in the record.
Again, I think Nancy was hung up on the resolution language. Sorry, Ms. Pease was hung up on that a little bit, and I do concur that what we're looking at is whether criteria 2 is met, and I do think
Yes.
that our finding is that based on the evidence we are looking at, the record, condition number 2 is met, because this project is consistent, the proposed use is consistent with the purpose and intent of the zoning district. I think that's a clear, we already determined that there is no errors made in that judgment. It's a multifamily development proposed, which is allowed in this district.
Okay. So how would you phrase the finding?
I would phrase it that the Board of Adjustment finds that the proposed use is consistent with the purpose and intent of the zoning district, the GR1 zoning district, and that's all I would say. And I guess if you need to justify that in terms of underlying documents, then we can get into that. But I don't think it needs to be more complicated.
Mr. Chairman, Mr. Diak, you might consider including the second part of the criteria 2, which is including any district-specific standards set forth in Chapter 2104. If you in fact believe that to be correct.
Mr. Wheeler, I do have a question on that, because 2104 is the zoning district resident. If you look at the residential districts in 2104, I think it was very Anchorage Bowl centric, if I want to say that, because it simply doesn't list any zoning districts in 09 and in Eagle River. It's basically the zoning districts in the bowl. If I'm missing something, you're gonna have to help me. But the GR ones, I don't think are coded there.
Yeah, I believe there's a cross reference, and it's going to take me a minute or two to find it again. I know I was looking at it when I was preparing the bench memo. Let me.
Okay, if you do know, I will.
Yeah, I'll
will
look.
go on your guidance on that.
Yeah. 2104 at table 21.04-1 indicates Girdwood districts are set forth in 2109.
It's in my footnote 10 on page 8 of the bench memo. 2104 contains descriptions and requirements for the zoning districts. 2104-010, table 2104-1 states that the Girdwood districts are set forth in 2109. District specific standards for GR1 are in 2109-04OB2A.III. More than one principal structure may be allowed on any lot or tract by administrative site plan review, which of course is superseded by the fact that this was done through the conditional use permit process. There's no other district specific standards.
And that is why I thought I just don't include it.
Well, I think because of the cross reference and the fact that criteria 2 does reference 2104, I think it's important to make that secondary finding as part of your decision, just to tie a bow on it. If you believe that the CUP application as approved by P&Z meets those minimal standards identified.
Mr. Chair, I would say that I would like to then include into the findings the underlying or the following, including any district specific standards set forth in chapter 2104. And if anyone wants to listen to the complications, how these are cross referenced, then they'll do that. So I think that will cover it. Thank you. Thank you, Dennis.
Okay. I agree with the way that it's worded now. Ms. Pease, do you have any concerns with this? Any further concerns?
No, I'm good.
Okay. If there are no objections, the proposed finding number 13 is adopted. Okay. Mr. Wheeler, are you, do you have to take a, would you like us to have a recess to allow you to take care of some business?
No, sir. I got a call this morning that canceled what I intended to do, so I am all yours.
Okay. Well, that makes my job a little bit easier. Okay. Let's take a look at criteria 6. Okay. Criteria 6 is the proposed use is compatible with uses allowed on adjacent properties in terms of its scale, site design, operating characteristics. And operating characteristics includes hours of operation, traffic generation, lighting, noise, odor, dust, and other external impacts. So, Ms. Pease, would you like to start discussion on this since you were interested in criteria 6?
Yes, in terms of the impacts, I guess my main concerns include whether the Planning and Zoning Commission adequately received adequate information and adequate consideration of traffic impacts. And the traffic counts, there were a couple of different, there was some range of traffic counts. I didn't find that the presentation explained how the traffic counts were generated. So I thought that was a weakness in the documentation. And that has a big bearing on whether the road access goes out onto road, which is bordering on the lower density residential, or Gunny Sack Road, or the highway, which are still within the GR1 and presumably therefore are capable of handling more traffic and more traffic impact. So that was one concern. The applicant, didn't provide evidence either about the traffic. But I guess I think that's a calculation that the staff and the 3MJ would be presenting, and their presentations weren't detailed and their methods weren't explained. So the appellant could have made a case statistically for traffic, but isn't really an expert and did not do so. So I don't know quite how to handle that. With regard to the other scale and other impacts, I think that the appellee 3MJ made a pretty good case about the height and the design of the buildings. So I think it's more the operations. As far as the other characteristics, the appellant didn't talk a lot about hours of operation, but obviously if this were rental units, that would be quite different. But I don't think we are supposed to interject any information or speculation if the appellant didn't raise it. So I guess it's mostly the traffic generation, which the appellant did have concerns with, that I think we need to address here. I guess there's one other actual element, and I don't know whether this is under 6 or under criterion 7. The 3MJ offered as one of their ways to reduce impacts their voluntary retention of 25% native of the original native vegetation on the site. This was not required, as it's not legally required. It was offered. It was cited as a mitigating factor. Planning and zoning did not nail down or pin down that mitigating factor by way of a condition. And looks as if it's kind of too late now. Sorry, we aren't supposed to refer to that photo, but
well, we
they didn't
refer to that photo and discuss that photo because it's not part of the record.
Right. Okay. So in any case, when there is a condition offered, when there's a mitigation offered, it's not really a mitigation unless it's part of the conditions. And since vegetation wasn't shown on any of the site plans, it was kind of a unkept pledge or it was an implied mitigation that planning and zoning didn't really provide because they didn't put it into a condition.
Okay, if I could address that point. I think mitigation refers to efforts that substantially impact the area, and it impacts a particular requirement. In this case, the requirement for vegetation tree retention in the record at R009 indicates that the GR1 district is exempt from providing the minimum amount of tree retention. So it's not a requirement that has to be met. And therefore, I think their mitigation wouldn't apply unless they were asking to eliminate all the trees. because they still have to have, there's a 25-foot, I think, setback, because it fronts the Alyeska Highway, and then you've got I think you've got there's a right-of-way, a public for an easement where the trees are located next to Gunnysack Road. That was mentioned in the record. So I think the promise of retaining 25% of the natural vegetation on the site, that's not an enforceable one.
Mr. Chairman, may I interject?
Yes.
I'm not sure that's quite the case. This group has taken this in a little bit of different direction than I wasn't anticipating, and so we may need to circle back to this, but typically if there's concessions made like this in the application is signed off on, the applicant agrees to be bound by those, and that becomes part of the basis of the Planning and Zoning Commission approval, that those will remain part of the conditions of approval. So they don't necessarily need to be called out specifically in the Planning and Zoning Commission resolution to be enforceable. But that's just the way I recall how this plays out, and I will have to confirm that. But I would not at this point assume that it's not enforceable. And I don't think that's an issue necessarily in front of you on appeal anyway.
No, that was not raised on appeal.
Mr. Chair.
Yes, Mr. D.
I would like to see how you see it structured, because then I would like to chime in as well with you said we are still in the discussion mode. I think Ms. P started it and you have followed. So I have a couple of items, and the first one of those items is that the appellant states that under this condition, which is number 6, compatible with uses allowed on adjacent properties. And that's part of the condition here. So if you look at condition number 6, and the proposed use is compatible with uses allowed on adjacent properties in terms of its scale, site design, operating characteristics, and then it lists what those are. So, so the appellant states the case that this particular approval does not consider the compatibility, and that's one of the challenges they made to this project. And I would like to say that because this project is adjacent to a zoning district that is different from its own zoning district, and also has this issue of access, which we have discussed already. The issue of compatibility comes in to address not just what happens on site, but how the site operates. And I believe this is the part of the challenge which does have some questions which we need to address. So in terms of scale, we have seen evidence in the record that the Pele has addressed the scale by looking at the building types being 2-story versus 3-story, which would be allowed, and that is the scale of the structure. However, if you look at the appellant's case, they're talking about the adjacent properties, and their scale is single-family residential lots, not only on the GR parcels, but as expected, even more on the GR2 parcels. And that is a type of development pattern which I believe is not properly addressed here, because you have now 3 duplexes and 1 triplex in an area which has single family structures pretty much all surrounding this property based on what I could decipher from the record. It is true that those single family dwellings are not on large lots. Some of them are a quarter acre or so, or even, I don't think smaller, but that's probably about the size. So if you look at the density, which was quoted in the record, about 1 to 4 units per acre, based on that math, that's true, except of course that the single family residence on a single lot is different than having multi-family. So I think there is some issue of the scale to be discussed in terms of development patterns. And the other issue, again, is operating characteristics. And to operate a site, you have to have access to it. And we have discussed traffic generation, which was proposed by the petitioner in the studies they made for this particular site. But I do not see any evidence that there was a traffic generation which was applicable to the surrounding neighborhood to see what the traffic is like. So you do have a proper comparison to make that determination whether these things are compatible or not. And I would like to see if you can help me if there is evidence to that. Let's find it. I just could not find it in the record, and I think those are issues which would be relevant to this particular issue, and I think those are raised by the appellant.
I think there is something in the record where they talked about traffic, and there's a certain threshold that where there's a certain amount of traffic that is that has to be proven before they will actually do a traffic study. And
yes,
I think
that's
based on
the municipal rules, which are looking at development for doing the study. But we're talking about the compatibility with existing conditions.
No.
What I do not see in the record is any kind of a comparison to prove that information is accurate. That would be the supporting documentation, at least for me, to see what is the current generation and the existing conditions, and then how would that be altered or modified or affected by the new project, or how would compare.
Yeah, I think I see the difference Mr. Diak is raising. You don't have to go through a formal traffic impact analysis, TIA, but there should be some comparison of traffic generated from single family homes versus a multifamily complex such as this. And I think it's also relevant to weigh in that there's often a fair amount of renting going on, or anticipated at least. And that's shown in the record. The owners may want to retain ownership and have this rented, and there may be short-term rentals. And so the traffic could be substantially different, I think, from single family. So short of a TIA, a legally required document, it does seem to me that the record is not very complete as to what the traffic patterns will be from this proposed 9-unit development versus the surrounding neighborhood of single family residences. And therefore, I don't know how the Planning and Zoning Commission can come to a conclusion that the operation will be compatible with surrounding development with regard to traffic.
Okay. So are you saying that the traffic study, lack of a traffic study, affects or degrades the substantial evidence supporting what the P&Z said? Are you saying that the lack of that now makes it non-sufficient if we had it or didn't have it?
Yes, I am saying that that is a weakness or a lack of evidence that raises questions about whether criteria 6 is met in terms of the operating impacts on surrounding uses.
Mr. Chairman, this is Dennis.
Yes.
For purposes of trying to fill out the record here, and the transcript at page 25, the applicant's representative did speak to the issue of trip generation.
Yes.
There's a couple of paragraphs at the top of that page that talk about trip generation, but to the commissioners, or to the board members' point, I don't know that there is anything in the record that speaks to this comparison between what they're anticipating for trips versus what currently exists in the area on the roads intended to be used. I know that staff in their staff report made a statement regarding traffic not being significant. I need to find the right page for that exact statement, so you have it. But again, it doesn't give numbers as to what is current traffic versus what might be anticipated. I want to say it's on T022, but let me see here. Yeah, it's the third full paragraph on T022. For approval criteria 6, we believe the criteria is met. Proposed development is similar in scale, etc. The residential use is not likely to generate excessive traffic noise, odor, or dust completion. But I don't see any sort of comparative estimating if that's important to the board.
Yeah, to me that is important, and also the statement here, the proposed development is similar in scale to other multiple family structures located along the Alaska Highway corridor. That to me isn't a evidence relevant to this particular unit. As I look at it on the land use map, it looks as if the other multifamily structures are over a mile away. So.
Okay, I think one thing I'd like to add, I think you're both talking in terms of what currently exists. And I think our job is to look at what is allowed by code in those districts, not what currently exists.
Mr. Chair,
I mean, that has to be.
I would like to have that discussion on that topic, because I think that has been brought up several times by the appellee. And if you look at the district specific standards, which I'm gonna have to jump to on 2109 on GR1, and I'm gonna pull it up from here because I think it's easier. So the GR1 zoning district states that the intent of this district is to continue the existing pattern of development as dwelling units are constructed on the remaining undeveloped lots, and to permit development of hostels, inns, and multiple family housing. I think that is a statement to acknowledge existing conditions. If it were not be the case, I think there would be no reason to have any kind of conditional permit review at all, because if you then go ahead and have no comparison to the existing conditions, then the whole purpose of the conditional use process basically nullified. I think it's relevant that as much as the development intensity, which is potentially allowed in a parcel, is not necessarily the driving force of what is compatible. And I think what you see in the condition 6, as the appellant stated, that their concern is incompatibility with the existing conditions, and they brought up traffic and scale, I believe was the other one. But the point is that I do think that we would err not to acknowledge that existing conditions do matter. That's why I think we have this case in front of us.
Okay, I agree with what you said, but I want to point out that there is an existing pattern, but the things that that are permitted, that like including the multifamily housing, in order for that to go in there, it has to meet the conditional use permit requirements. And that's where
Yes.
your existing comes in, is under there. How does that fall into, and how is it considered under the conditional use permit criteria? So in that matter, I think existing use is appropriate for discussion, but it is not it's not the prevailing issue in all of this. Is just what is compatible under and appropriate under the conditional use permit criteria.
Mr. Chair, I concur that yes, the criteria is what drives the consideration of the conditional use application, and in this particular case, what I brought up about traffic counts, I do not think that the Planning and Zoning Commissions had ample evidence of a comparison to ensure that evaluation was done and there was evidence to support it. It doesn't mean that that the project as it is not compatible. What it does mean is that as it is now in the record, I do not know if there's any evidence to prove that it is incompatible in terms of traffic patterns. So as far as findings go, perhaps that is one where I do think that the Planning and Zoning Commissions did not have the information at hand to compare existing patterns with the proposed ones.
And that's sort of where I started out, that the record is not complete, and therefore it's hard to make a judgment with regard to traffic generation and the compatibility of the traffic on the existing level of uses allowed.
Okay, so do you think on this particular issue that there's let me put it this way. If this particular issue is one of the main drivers, are you saying that this particular criteria needs to go back to the P&Z to develop sufficient evidence? And what I think what we're looking at now is this, what you're saying is there's insufficient evidence to actually consider traffic impact on the area without more definitive information.
Mr. Chair, I would say that based on the record, I do not have, I did not discover enough evidence to allow the issue to be vetted properly, because the existing patterns are existing as they are, but I did not see evidence of those patterns being evaluated for the traffic. I only saw evidence of the new project's traffic generation, which did not hit the threshold of municipal traffic impact analysis. That's, I think, two different things. What you're trying to decide, whether it fits the neighborhood, especially with the traffic being from the internal road rather than from the highway. I think that's what I think this actual appellant objection is raising.
Okay, are there any other issues that appellant has raised that might affect criteria 6?
Well, again, the appellant raised affordability under criteria 6, and I don't think it is a consideration under criteria 6, but I think we should go back and see if we adequately address that with regard to criteria 1.
Okay, we can still do that.
And Mr. Chair, I would like to just clarify that the whole issue of traffic for this particular project is brought up for the simple reason that this project does not propose accessing Alaska Highway, and therefore traffic becomes an issue. I don't think that would matter if the access to this parcel is from not Strout Road.
Yeah, that's my impression too. The appellant did, talk about the concern about the new development being used primarily for nightly rentals, which would give it different operating characteristics from the adjacent properties. But the appellant didn't really elaborate on these concerns other than to say, well, on page 4, will generate additional traffic, dust, noise, garbage. We're talking about the traffic, because there was some statistical evidence, but not enough given on that. But with regard to dust, noise, garbage, etc., the appellant did not elaborate, and I don't think it's our responsibility to make that case.
I think we have to look at what the appellant has raised as issues.
Yes.
Okay, so then when the appellant merely says not compatible with the operating characteristics of the adjacent property, will generate additional traffic, dust, noise, garbage, etc., are we then charged with sort of spinning through the scenarios as best we can from our experience? There's nothing on the record regarding, for example, garbage. If you have nightly turnover and the garbage has to be taken out every day, it's going to be a different garbage generation pattern. But are we supposed to go ahead and work through that? Was that the appellant's job? I mean, just to be a little clear on that, if you have nightly rentals and the occupants, there's no host on site, so the occupant's supposed to put the garbage out, and it's a bear problem area, and there's nobody who's responsible once the bear gets into the garbage. That's a problem that's different from adjoining owner-occupied or long-term occupied properties. But are we supposed to state that for the record, or should the appellant have stated that for the record?
Mr. Chairman,
Yes.
we need to stay focused on what's in the record as evidence.
Okay, that's what I kind of thought.
So from what I can see in the record, there's sufficient information on the scale, site design, but the rest, the operating characteristics, you're saying that it lacks sufficient information to make a reasonable determination.
I did say that, yes. That was my contention based on page 3 of the appellant's brief, and I think it's in the bottom of page 3 where it talks about lot zone G1 in this area are along the Alaska Highway corridor. This proposed project is attempting to bring large multi-family development, which is a significant anomaly in the area, not through the appropriate highway corridor, but instead oriented towards an access through the GR2 area, which is not compatible or developed to be used in this manner. So for the Planning and Zoning Commission to make a decision on operating considerations, I do think that the evidence is not there to to support their decision. I do not see any kind of comparison between existing conditions and traffic generation for the project. Although we do know in the record there is a good amount of data on traffic generations from this particular project. The petitioners did a good job to produce that. As far as scale and compatibility, I think we have talked about petitioner and the appellee referencing the site design as well as the building design in terms of scale of the buildings being 2-story. As far as development patterns, the site design speaks for itself what the pattern looks like. It is definitely up to interpretation whether that fits the neighborhood, but I think the evidence was present to make that judgment by Planning and Zoning Commission, because the patterns were also there for the surrounding existing area. They could make an inference whether that's compatible or not, and that's what it seems that they have done that.
I agree with almost everything Mr. Deox said, Mr. Chair, but I would say that I would like to have seen more documentation of the traffic generation estimates. I think it's important to show the methods or the model.
Okay, Mr. Diak, are you in agreement, or what you're saying is that you think that there's sufficient information regarding the traffic patterns?
No, actually, I'm saying the opposite. I do not think that there is sufficient information regarding the comparison, traffic generation comparison, but I am in agreement that there is sufficient data to compare development patterns in terms of scale and their compatibility. That was available to the Planning and Zoning Commission, and they made their judgment on that.
Okay, I think that there's substantial evidence in the record, and it what is it? I want to look at that again. What was it? This, oh, I don't have it right in front of me again. Scale site design. I think there's significant evidence in the record that shows that has been considered, because the appellee indicates that they changed and lowered site lines for the structures, and they provided extra off-site parking. And they talked about natural vegetation. And of course, natural vegetation, they may or may not have done that, but that's not a question for us. If the question is the site and the scale affected site design? And I think there's ample evidence for that to support it. So let's look at traffic again. Does that, you believe that because of the lack of information regarding traffic, that and its implication with the rest of the, we got noise, dust, and other external impacts. Do you think that is sufficient for us to send this back to the Planning and Zoning Commission and have them look at this issue further?
Mr. Chair, I think the options which we have in front of us as a board, we probably want to consider before I answer. But I do feel that based on this record, I don't think that there was ample evidence to make a determination either way. And one item on page R18, which is the staff's statements regarding this condition, which is number 6, it says that this residential use is not likely to generate excessive traffic. Just that in itself tells me that that we are not in a position to make a judgment, because there's no evidence they pointing to either. So that would be where I would say yes. I think this would be a substantial issue to revisit and have an examination at the lower body to make sure that this is properly addressed and the decision is made, and then the case is moved forward.
Well, if we apply the same standard that we looked at, or the assertions on some of the other issues that we've discussed, this seems to be, in fact, an assertion without very much evidence to support what he said.
Yeah, I believe so, yes.
When you say he, you mean the staff report?
Staff.
Yes.
So I'm just looking at this, and I think one of the things we could do is to have a finding that there is sufficient or let me look at it this way. There's substantial evidence.
Mr. Chairman, if I
Yeah,
might
go
help,
ahead.
as I understand this, the basic premise here is that there's insufficient evidence in the record. And so the question you need to ask yourself here is there insufficient evidence in the record on an issue material to the decision of the case? And if you think this is material to your decision in the case, then what happens is you make this finding that there's insufficient evidence in the record, and that would give you a basis to remand the case for that issue. And then what you want to do is, if you do go that route, is you still want to finish out the rest of the issues on appeal here, so that if there's more than one thing that gets remanded, that's clarified. If this ends up being the only issue, that's clear as well.
Okay, so if we refer to criteria 6, we're referring only to a portion of it, but you think if we just look at, have the motion refer to criteria 6 by itself?
Mr. Chairman, from what I've heard from the board, I don't know that all of 6 is at issue. So
That's my point.
Yeah, you just need to, if it's more narrow, then you need to be clear about that on remand.
Okay, that's why I'm looking at possibly two issues here. One, that there's sufficient information, or there's substantial evidence to support conditional uses relating to scale and site design, and make that one finding, and the other would address operating characteristics, that we would find that operating characteristics what would you say, that was there would be insufficient evidence of the record?
Yes.
To address operating characteristics and make reasonable decisions
I would
Okay.
suggest a further dive in on the operating characteristics, because you certainly have talked about traffic generation, but I don't know that you've touched on whether you would think there is or isn't sufficient evidence for P&Z findings as to hours of operation, lighting, noise, odor, dust, any other external impacts. Focusing
Mr.
on
Chair,
what's
may
been raised.
I ask counsel on something on this one?
Say that again, Diak.
I'm just hoping that I may ask counsel something about this particular issue.
Yeah, go ahead and raise it.
So the question is that do you see, Mr. Wheeler, do you see that we have to be completely narrow on the operating characteristic issue itself? Because traffic generation will come with noise and dust for this particular place. The other three, I believe, were not raised, or there was no evidence to raise them, and the appellant have not raised them either. So do you see that we have to go and pick out the individual ones which relate to traffic, or we can just have the operating characteristic be the issue?
Mr. Chairman, Mr. Diak, I think you do need to be more specific, because when you remand, you're asking the parties to generate additional evidence, including testimony on these issues. So if you're finding that issues of hours of operation or lighting or noise, et cetera, are fully developed or sufficiently developed in the record as is, and you can make a decision that those criteria are met, then you want to be clear that you're not asking for the development of additional evidence on those points. So you're going to put some people to task to work on these issues. So you want to be very clear about what you do want to hear more of, and what you think has already been sufficiently developed in the record.
Okay, Mr. Chair, if I may then clarify this. So I do believe that that the issue is where the evidence is insufficient is regarding traffic generation, and with traffic generation, of course, comes the other secondary issues with that, which is dust. In this particular place, we have heard about some improvements to one of the streets, which is Sprout, but not others on Gunnysack. And those two would be definitely a part of my statement. And traffic generation, dust, and then of course we can discuss whether noise comes here. I did not see it directly because this is proposed as residential use. Therefore, the noise requirements probably are compatible with the residential use, and I did not see evidence either way to dispute that.
Okay. I agree with you. What I see is there's substantial information in the record regarding lighting. They've taken a lot. That was a big issue. They've taken a lot of mitigation efforts there. Hours of operation, I don't know if that's really impacted or not. Hours of operation seems to me like it would go to more of a type community like hostel or an inn. So I think that's not a key element here. But traffic generation, noise, dust, and would we be also asking them to look at related external impacts and other related external impacts? Or that's very general, it's not very specific.
I think we probably should. The appellant did raise the concern about use primarily for nightly rentals. That certainly affects, in my mind, hours of operation, or it could create different hours of operation from a standard residence.
Wouldn't
So-
hours of operation, I mean, that's very, it's very, it seems to me like it's a very narrow look at how that particular site is operated. Is it operated as family dwellings? Or is it operated as, what would you call it? It's more like on close to the commercial side.
Yeah, commercial hotel type.
I guess it's, there's a section. I don't know where it's at, where it's a table that deals with density uses. Yeah. Hostels, inns, it's categorized under visitor accommodations.
Yes.
I think that's where hours of operation would come in. So I don't think we need to address hours of operation.
Mr. Chair, I would agree that the hours of operation potentially is not the main thrust here. Based on the appellant discussion, one of the concerns was more about the pattern in which these units will be operated. And it says on page 4 that a particular issue has been raised during several public meetings as the neighbors in the community are concerned about the new development being used primarily for nightly rentals, which is not compatible with the operating characteristics of adjacent properties. I think that would be an external impact, and I think that could be the one where we ask for some examination. The record already has included references to commitments or lack of commitments to have these owner-occupied or longer-term rentals. And I believe there was a motion which then did not make it to the table. It's in the record, Planning and Zoning Commission hearing, when one of the commissioners raised the issue to get a condition into the record, which would require 30-day rentals, not shorter ones. That motion was not brought up. No second was made, and therefore it never passed a step forward. But that to me does not necessarily mean that the issue of impact of short-term rental has been addressed properly.
Okay, if you put short-term rental as a caveat on those on the particular lot, it's going to affect the. I think it's going to affect the marketability should anybody decide to try to sell, because what buyer is going to want property with a restriction like that, and the other is a restriction like that normally is handled through covenants, and covenants are usually generated by the housing association.
Yes, Mr. Chair, I by no ways indicated that I want to imply any kind of solutions from us. What I was bringing up is that the external impact as such, I think does not have sufficient evidence to address that issue, which was brought by the appellant. It is in the appellant brief.
Yeah, I would agree, Mr. Chair. We're not in any position, nor are we trying to imply or apply solutions in terms of rental restrictions. That's way outside of our scope here. But it is, I think, our job to ensure that impacts are thoroughly explored so that the Planning and Zoning Commission can apply proper mitigations. And in the case of the potential impacts from nightly rental type of operations, I don't think those have been explored and documented. So I think we need to include that as part of the documentation that planning and zoning should consider. I mean, I think we need to ask that that documentation be part of a reconsideration or remand.
Mr. Chair, may I jump
Yes.
in for a moment? I just want to note that we're just about 7 minutes over our scheduled meeting time. So if the board wants to continue, briefly to finish this finding, we might entertain a motion to extend for a short amount of time. And then we could also look at a continued meeting date that pleases the board.
Okay.
Mr. Chair?
Yes.
May I do that?
Go ahead.
But you will discuss it. So just to speed things along, I make the motion to extend the current meeting to 3 p.m. to wrap up business, in order to wrap up business.
I would like to amend that so that we give ourselves a little bit more time, because I need to check to see if everybody can actually attend, but I'd like to go for 3:30, just as a cover.
Yes, I would concur.
Mr.
Okay.
Chair, my apologies to the board, but I cannot stay on as your staff for that long. I could stay on until about 2:30 at the latest. I apologize. I did not realize we would extend this far.
Okay. Do we have someone to conduct or take your place and conduct your duties?
I can check in on that. We'd need to take a brief recess to stop the recording and then allow someone else to come in. So I'd need about a 10-minute recess to see if that was possible.
Mr. Wheeler, is this extension okay with you, or you have the time now, or do we need to delay this until another date?
Mr. Chairman, I'm good all day.
Okay, and my schedule is similar. So
okay, so the motion to extend is until 3:30, and if we could, if the board would like to extend to 3:30, we could take a brief break and try to find another staff member to come in and assist you.
I would like to do that because I don't think there's any way we can finish this by 2:30.
Understood.
Okay. I second the motion. Any discussion? Okay. We're going to recess for 10 minutes and see what we can come up with for additional support for the board to continue until 3:30, or 3:30. Okay.
Very good.
So we're back at 2:20.
20-minute. Did you say a 10 or a 20?
No, I said that 2:20 p.m.
2:20 p.m.
Is that, Madam Clerk, does that give you enough time to find a replacement?
I will certainly try. Yes. Let's go with 10 minutes.
Thank you.
Okay. We'll reconvene at 2:20 p.m.
Thank you.
We're in recess.
Thank you, board members.
And the Board of Adjustment meeting is back in session. Okay. In order to try to narrow this down, what I'd like to do.
Mr. Chair, may I jump in right away and interrupt
Yes.
you? My apologies. I don't think we actually acted on the motion.
No, we've been discussing, but we haven't really agreed on
I
anything.
meant the extension.
Mr. Chairman,
wait
he's
a minute. You're right.
speaking to the extension of time.
Okay.
And please confirm with the clerk that the recording is on.
Madam Clerk, is the recording on?
The recording is on, Mr. Chair.
Okay. Thank you, Ms. Jones. Okay, we had a motion on the floor to extend to 3:30 p.m. today. Hopefully we can get our work accomplished by that time. Did we have a second?
I'll second it.
Okay. Our counsel is available. Our clerk is available. Are both of you, Mr. Deek and Ms. Pease, are you available until 3:30?
Yes.
Whatever it takes.
Okay. I'm available for as long as it takes. Okay. Madam Clerk, would you call the vote?
Mr. Stewart,
Yes.
I'm muted, I'm sorry. Mr. Diak,
Yes.
Ms. Pease.
Yes.
Motion passes.
Okay. I believe. Oh, I'm hearing a lot of background noise right now.
Oh, I apologize, that's me. I'm at the election center. I'll try to keep myself muted.
Okay. That would be, I'm trying to pick up, that would be motion. Oh, which one would it be? I think that would be motion number 6. I'm not sure.
I think that's what you stated before, Mr. Chair.
Okay. Motion 6 was approved unanimously. Okay, in order to try to bring this into perspective, this is wordy, but I think it needs to be in order to try to select out what actually we're concerned with and what is sufficient in the record. So here's what I propose. The Board of Adjustment finds there is sufficient evidence in the record to support P&Z's conclusion that the proposed uses, I'm sorry, it's the proposed use, I felt, is compatible with the allowed uses on adjacent properties in terms of scale, site design, and parts of the operating characteristics to include hours of operation, lighting, and odors. And my intention is then to do another finding that is what is insufficient in the record, and that would be going into the same thing, compatibility with regards to traffic generation, noise, dust, and other related external or other external impacts related to traffic. So I'm trying to narrow it down. Okay, you want me to repeat that again?
Mr. Chair, I think the first one is clear, but the second, so are we just acting on the first one or discussing
Just
the first one? Okay.
Yeah.
That was clear.
Okay, Ms. Pease?
Yeah, scale, design, hours of operation,
Lighting and odors.
Mr.
Okay.
Chair, if you could please read it again for the clerk.
Okay. I know this is long, but I wanted to repeat part of the criteria. The Board of Adjustment finds there is sufficient evidence in the record to support Planning and Zoning Commission conclusion that the proposed use is compatible with allowed uses on adjacent properties in terms of scale, site design, and part of the operating characteristics to include hours of operation, lighting, and odors.
Thank you.
Okay. The other, there any objection to finding number 14?
No objection.
No
Okay.
objection.
Seeing and hearing none, finding 14 is adopted. Let's look at finding number 15. Here's what I'm proposing. Board of Adjustment finds there is insufficient evidence in the record regarding compatibility with regards to traffic generation, noise, dust, and other external impacts that may be related to traffic, period.
Just for parallel with the previous statement, did you want to say regarding compatibility with allowed uses on adjoining properties?
You know, I think that's a good fix. We should probably just, yes, use the same language.
Yeah, Mr. Chair, I think we just use the same language that will be consistent. And then when you're ready, I have one comment on external impact.
Okay. I would like to add the right at the end of that, after traffic, just put traffic generation.
You mean to external impacts?
Right.
So this is what I would like to propose. We already have the discussion on traffic generation in the list because that's part of the items we're looking at. I think we have discussed in some length the reason for traffic generation in regards of this whole issue about long-term or short-term rentals. So I think what we may want to do there, external impacts, including use patterns or something along those lines. And that's where I could use some help, because we do have the issue of traffic generation and any kind of patterns which are different than the proposed multifamily standard in our codes and in our processes to check against those for traffic may be impacted by the way how these units are used. And that was part of the appellant's discussion in this particular instance.
Mr. Chairman, if I might.
Yes, Mr. Wheeler.
In support of what Mr. Diak is saying in terms of what's available to us on the record, I think I know this previously, but in the transcript at 025, the applicant is talking about traffic and mentions that really the worst case scenario is if each units, which are 3 bedrooms, were rented out per room like a hotel, and that would generate 13 trips in the peak hour, et cetera. So the applicant is indicating that, you know, while they're not anticipating that this property be operated in that fashion, it's certainly something that should be considered, I think, in terms of P and Z looking at impacts based on the, as Mr. Diak said, the range of potential uses under the CUP.
Okay, which was that T or R25?
That particular reference is in T025. I think it helps give context to why you're asking the question.
Mr. Wheeler, maybe you can give us a hand on the finding itself. Then I think the phrasing is where I was not completely sure how to do it, but I agree the intent, my intent at least, would be exactly what you stated.
Mr. Diak, I think your phrase, the range of anticipated uses was fine. You could say range of anticipated uses under the conditional use permit.
I'll need this sentence read to me so I understand where the range of anticipated uses fits into what we've already generated.
Okay. We could add that right at the end of that phrase, traffic generation, including range of anticipated uses.
How about considering the range of anticipated uses under the conditional use permit? The idea being that the anticipated traffic generation is somewhere between the property being used as 9 owner occupied units versus 9 hotel style units with a completely different level of traffic generation.
Okay. Madam Clerk, would you be able to read that motion back to us now? Or I'm sorry, reading the potential finding?
Yes, Mr. Chair. What I have is for finding 15, there is insufficient evidence in the record regarding compatibility. Oops, did you know I don't have the parallel language from the previous motion, but I have a note to include that.
Okay, it says with allowed uses on adjacent properties in terms of, and then it goes into detail.
And the detail that I have is with regard to traffic, noise, dust, and related external impacts that may be related to traffic generation, considering the range of anticipated uses under the conditional use.
Okay. Okay, I'm satisfied with that, Mr. Deeg.
Yes, it's excellent work. Thank you, Ms. Jones.
Yes.
Okay. Dennis, does that make sense? Mr. Wheeler?
Yes, sir.
Okay. All right. Any objections to adopting finding number 15? Hearing and seeing none, finding 15 is adopted. All right. Let's see.
Barbara, could you mute again, please?
So So we had 14 and 15. Okay, Mr. Wheeler, do you think we need to address this now as to? No, I think we should. I think we should wait and address what we need to do and how we want to handle it after we get through the rest of this.
I'm sorry, Mr. Chairman, handle what?
Oh, I was going to look at how we're going to handle getting this, looking at it, how we take care of this discrepancy with the P&Z physically, procedurally rather. But I would
Mr. Chair,
prefer to go ahead.
if I may, are you saying that we're gonna go to criteria 7 first?
What I'd like to do is hit criteria 7. And then after that, we'll go back and look at the motion on issue 5 and take action on that. And then we need to go back and take a look at criteria 1 again. And then we look at what we want to do for any further findings and conclusions and how we're going to make our findings and decision. Okay, criteria 7. Are there any significant impacts anticipated to result from the use? Whether they will be mitigated and offset to the maximum extent feasible. So we're looking at possible impacts. If they are significant, then there should be some mitigation or offset to the maximum extent feasible. So the appellant argues that the applicant has not taken into account the community concerns. I don't know if that's a significant impact, but appellee notes in criteria 6 that the applicant is asking for fewer units than might have been incorporated. And they've impacted the, or they've set up methods to lower the impact design elements. So both of those kind of mitigate and offset adverse impacts. I do note that in the record at 100, R100, the Girdwood Board of Supervisor meeting minutes indicate that based on neighborhood input, developer has scaled back plans to 9 units per originally 12. So what that means is there has been some impact that was noted, and at least in that Girdwood Board of Supervisor meeting notes at record 100, it shows that there was an intention to go with 12 units, and that was scaled back to 9. So I think there's significant evidence in the record that shows that, at least from what I can see, there is significant mitigation that has been taken, but at this point in time, I don't know if it's the maximum feasible. This might be an issue regarding Alyeska Highway, because I don't know if that's a legal impossibility to access Alyeska Highway, or I do know that it's in the record, they indicated it's infeasible of developing Gunnysack Road, to bring that up to the development, because it would have to, they've got significant slope issues, you've got sewer issues, and it would be a major problem. And I think that's in the record that indicates the appellant looked at this, the Gunnysack Road development, as something that could not be done. And it would actually stop the project, because it would not make it feasible at all. So that's what I've got so far. Mr. Deek.
Yes. Mr. Chair, I have no idea why I echo.
It's not bad. Go ahead.
Okay. So, Mr. Chair, so on this particular issue, appellant states that that the petitioner has worked with the neighboring residents to mitigate impacts to the natural environment, has taken their concern into account. It also states that this is a subjective statement that could be considered true or false depending on perspective. I do believe that efforts have been taken based on the record, that efforts have been taken to address some of the concerns. But I would also point out that this application is not for 12 units, it's for 9. So
Right.
it is currently in front of us for that particular number, not for a higher number they may have considered in the past. So in terms of that, I do think that there is evidence that mitigation, at least the discussion for mitigation has taken place. There is no question that appellant, although they do not say that, appellant acknowledges that there were efforts by the petitioner to meet with the Board of Supervisors, have other meetings with the Planning Committee, and then obviously they had to go through the public process to get to this point. The question is whether there is enough has been done to the maximum extent possible to make efforts to mitigate significant adverse impacts. I do believe that the petitioner stated their case. They have produced the evidence for what they see as mitigating, and the Planning and Commission had that information available to them, and they made a judgment based on the information, whether that was a maximum extent feasible or not. So in that regard, based on the petitioner statement that this is a subjective interpretation, I do believe that the whole process of planning and zoning review is based on information and evidence, but it is ultimately a subjective decision by the members of the board who feel whether the information was sufficient for them. And I do not see any reason to think that the information was not present for them to make that judgment. So I would say that in this case, there was sufficient evidence to make the determination. Whether it is supporting the statement is the question here by the appellant, because he proposes that it was subjectively interpreted rather than objectively. And I'm not sure whether we have any standing on determine that, but we do have standing whether information was provided to be able to make the determination. So I think there was evidence to be able to do it.
Ms. Pease.
Yeah, in terms of the evidence, I'm not, maybe have a little bit different perspective here. If the commission did not have adequate information on traffic impacts, then they are not in a position to mitigate or offset those impacts to the maximum extent feasible. That's one concern. With regard to possible diversion of that traffic out to Gunnysack or to the Alyeska Highway, there wasn't, I expressed this earlier, I didn't see documentation that either of those was not possible. With regard to the Alyeska Highway, I guess I would consider the ultimate evidence to be an application to DOT and a denial, and that wasn't there. There was supposedly a denial on the adjoining lot, but that wasn't presented into the record. And then with regard to Gunnysack Road, I guess just my own experience has been in the past that if it's difficult, the applicant will say it's impossible. But I think it's necessary to have some kind of documentation. Gunnysack Road has a more gentle grade at the top of the road. That would be the west end of the road than it does at the bottom. So it's not totally clear to me that Gunnysack Road is out of the question without some kind of documents beyond the applicant's testimony. So I think the record is weak with regard to the mitigation possibility of directing traffic to Gunnysack Road or Alyeska Highway. And then with regard to the offer to retain 25% of the vegetation on the site, that is part of the applicant's part of the application R-035, but that wasn't incorporated into any conditions. And I know that one of you said earlier that the application is can be adopted as a whole, and the developer can be held to the standards of the application, but it's not shown on the site plan, and so it's in the narrative, and I'm not sure that is actually therefore a condition. And it would seem to me that to mitigate the density, the applicant was offering to retain vegetation, and the Planning and Zoning Commission could have, and in my view probably should have, stated that as a condition. It's not legal, but it's an offer. It's offered as mitigation, and therefore, if it is to be mitigation, it should be formalized.
Mr. Wheeler, are you aware of any decisions that have come out of the court system regarding adoption of promises made by the applicant in the CUP applications, putting a mandate on the applicant that must become part of the conditional use criteria?
Mr. Chairman, I'm not aware of any court case off the top of my head, but as I tried to mention earlier, I think it's a code-driven requirement, so I'll try to find that.
Okay.
Mr. Chair, may I jump in for a moment and state that I was a bit too quick to discount the correlation between various conditions of approval, and I would concur that the information being sufficient certainly does not apply to traffic. So I pulled it out from my my review purview because it was not in the appellant's discussion. But listening to Ms. Pease, I would have to say that logically, if it was not available for condition number 6, it certainly was not available for condition number 7, and therefore the mitigating impacts could not be examined. So I would concur with that.
Okay. I'm looking at this, I guess, a little bit from a different perspective, in that I'd like to address the Gunnysack Ms. Pease brought up, the infeasibility of developing Gunnysack. There was considerable discussion about the grade, and the grade was of a certain 30-35%, somewhere in that range. and that would require resiting the sewer system. It would require redoing the entire road, but then there was some discussion about if you did do that. There was also a discussion about some of the safety issues regarding that would be part of the compatibility of putting traffic, high traffic volume down that a steep grade, recognizing that there was a lot of traffic on the there's a trail right there, putting a high volume, two high volumes of traffic, foot and bicycle and whatever else on the trail, intersecting with a major highway and coming down a steeper grade than what is available getting up to Sprout Road. So I think that all looks at the feasibility of utilizing Gunnysack. So I wanted to get that on the record. The other thing is, I don't know if there's a legal inability to access Alyeska Highway. That could be something that the Planning and Zoning Commission could develop. Maybe there's more information, or maybe there's information from the Alaska DOT as to why they are not allowing access onto the Alyeska Highway direct from lots. I don't know if they have an internal procedure or if it's just they're operating from legal opinions that require non-access and except in certain cases. I don't know that. So there is a possibility that information could be generated resulting to impact the traffic pattern, whether or not there's a feasibility of even putting it on the Alyeska Highway. And I can tell you from what I saw on the record, it would be very difficult from a safety standpoint and from compatibility with the requirements of, you've got a steep grade already on Gunnysack, and if you put a access direct onto Alyeska Highway from the lot itself, you're going to have traffic very close to the intersection of Gunnysack and Alyeska Highway. So you're going to have the same problem that you would have if access were actually granted there. So there would be significant issues, safety issues for sure. And I think that would be looked at as whether or not that would even be compatible with the surrounding area. And the surrounding area, in this case, would look at traffic on that trail, traffic on Alyeska Highway, and other traffic that would come down Gunnysack. So I throw that into the mix, but so it looks to me like there's a balancing act here. If we send it back to have more information developed on access to the Alaska Highway, that raises a lot of significant issues on compatibility and safety issues, because you're going to have a lot of traffic very close together between, and it will impact Alyeska Highway and the trail. It makes for, I think, some potentially damaging safety conditions.
Mr. Chair, I think everything you're raising is valid. I'm just suggesting that this should be part of the record that's submitted to Planning and Zoning Commission, that they should solicit, and we shouldn't have to be speculating about it. I agree that it doesn't seem very likely that Alyeska Highway is the best outlet, but I think that should be shown to Planning and Zoning Commission, not the basis of speculation and secondhand assertions that DOT would never go for it. Likewise, with Gunnysack, there's going to be extra traffic on Gunnysack from this development. So is now the time to, upgrade that road? When does it get upgraded? If it really is 35% grade, and this is going to put more than the, because of the extra density, this is going to increase the traffic above the traffic expected from permitted uses, then this is contributing to conditions on Gunnysack. And so, it's just an issue. I don't know the answer, but it's an issue that I don't feel was explored in terms of trying to have mitigation or offset from the extra traffic to the maximum extent feasible.
Mr. Chair, if I may follow up a couple of issues on this issue. I think that Ms. Pease, I would concur with Ms. Pease that the issue of mitigation is probably most crucial in examining whether it was offset to the maximum extent feasible for traffic. We do know that there were statements made for access to Alyeska Highway. We do not have evidence that there is a definite answer, but you can project, and that's what the petitioners did. We do know that there was some analysis of sorts which they referenced to determine that Gunnysack Road is too steep, but it's not too steep for driving cars to go up to Sprout Road. It was too steep to meet municipal standards without rebuilding it to create the driveways, and I think those are two different issues. If this project is approved at whatever density, let's say it's a CUP right now, it's looking at 9 units. Those 9 units will use Gunnysack as their access. We know that because they can get to the other street without accessing that road. So I think the issue here is whether the mitigation is to the maximum extent feasible. And the appellant again states that the information was there, but it was subjective in its interpretation because not all the evidence was presented for these assertions to be substantiated. And I think that would be my concern about this particular one, that traffic in itself raises a whole host of issues. We have dealt with some of them under condition 6 or criteria 6. And I do believe that it basically carries through or is applicable for criteria 7. So I do think that as much as there is sufficient evidence to make mitigation decisions by the Planning and Zoning Commission, it does not necessarily seem to me that it was sufficient for the traffic issue. Again, when I started out, I separated that, but I realized Ms. Pease is correct that it is part of the mitigation, so it should be in this actual criteria as well.
Okay, so what would you like to propose the finding be? We're probably going to have we might have to have 2 findings on this, but what would you propose to make a finding reference the adverse impacts and maximum mitigation or offset?
Just a second. So one of the findings, Mr. Chair, one of the findings I think would be to be considered perhaps is to state that a Board of Adjustment finds that the petitioner appellee has worked with the neighboring residents and their representatives to develop a proposal which was then submitted to the conditional use permit application. I think that's a fact, that's a finding, and it has substantial evidence to support it. I would probably state that because I think that's one where we can definitely find the evidence in support.
Okay.
Could you read that back? I'm not quite sure I grasped the.
Did you write that down, Mr. Deek?
I did, but I'm gonna repeat it. So the Board of Adjustments finds that the appellee, or I guess at that time petitioner, has engaged and worked with the neighboring residents and their representatives to find mitigation solutions or mitigation for this project. Simply stated that.
Would that be engaged and worked with the community and residents to address?
Yes, that would be sufficient. And the goal, the intent here is that we do need to show that the record is clear, that there was an actual process going on between the appellant and the appellee, and they have worked on these various issues.
Okay, so yeah, I like the use of the word to address mitigation solutions for this project.
Okay, so we're at the board finds appellee has engaged and worked with community and residents to address mitigation. Oh, wait a minute.
Solutions.
Mitigation solutions to this project. I think there is substantial evidence in the record to support that. And it's a positive finding. Okay, any discussion? Any objection? Okay. Finding number 16 is adopted. Now we still have to figure out how to look at the insufficiency of evidence in the record addressing the it would be the traffic generation and we talked in terms of process of allowing access or denial of access to Alaska Highway.
Yeah, the process of documenting whether there was the possibility of access to Alyeska Highway.
Mr. Chair, if I may, I think it would perhaps would serve us if we would phrase this next finding regarding this issue similarly like the one we just did, which was basically, if I give it a shot, it may be the Board of Adjustment finds a lack of evidence to prove that the proposed mitigation efforts have actually been offsetting the impacts, adverse impacts to the maximum extent feasible, because that's where we don't know. The feasibility issue is the issue, I think. I don't know, Ms. Pease, maybe you want to help that one, but that's my start.
Okay, so can you, the Board of Adjustment finds that the appellee,
finds that insufficient evidence exists that the mitigation efforts proposed by the appellee have addressed the adverse impacts to the maximum extent feasible.
okay, and then do we want to say with regard to direction of traffic onto direction of traffic onto Alyeska Highway or Gunnysack Road?
I would be good with that, yes, to define it better.
I think you're talking documenting the process of accessing or denying or getting access to the Alaska Highway or Alyeska Highway.
Yeah, and also the impacts to Gunnysack Road.
Yes, both of them.
It's not just directing traffic onto the road via a driveway, but the additional traffic generated by the additional units.
Okay, Ms. Pease, have you got that down, or should we ask the clerk to read it back?
What I wrote down was with regard to the direction of traffic onto Alyeska Highway and or Gunnysack Road, including the traffic generated by the additional units. So it's not very grammatical. So including the impacts, I guess, the impacts of traffic generated by the additional.
So, Ms. Pease, could you read that one more time? I'm sorry, I had something slightly different on that last phrase. I had the maximum extent feasible with regard to access to traffic on the Alyeska Highway or impacts on Gunnysack Road. And I don't know if you wanted and or, but I think I missed something there if you'd like to help me.
Okay, with regard to the access of traffic onto Alyeska Highway. And then what?
And I don't know if you want an and or an or, but I heard impacts on Gunnysack Road.
Okay. Okay, so I guess
It should be and.
Okay. I don't think it makes a big difference, actually. with regard to the access of traffic onto Alyeska Highway and Gunny Sack Road, including the impact of traffic generated by additional units. I don't know if you like that wording or not.
Okay, Mr. Wheeler, can you help us with this? Do you think this adequately defines what we're looking at?
Could I indulge in the clerk to read it back one more time? Madam Clerk?
I think I'm missing something a little bit closer to the beginning. So I'll read what I have and tell you where I might need a little more help. The Board of Adjustment finds that insufficient evidence exists to prove that Applee's proposed mitigation efforts have actually been, and I don't know what the word is there, to the maximum extent feasible with regard to access to traffic onto the Alyeska Highway and impacts on Gunny Sack Road, including impacts of traffic generated by additional units. Thursday. So exactly.
Mr. Chair, that seems like there's some extra wording in there. We could probably skinny that down.
We're trying to keep in the details about the issues involving traffic, but I'm not sure that it's something that we needed to prove. We have to generate, there has to be sufficient evidence in the file. And we're saying there's insufficient evidence to make a reasonable determination of mitigating or offsetting to the maximum extent possible the impacts.
Understood, but would it be the case that we wouldn't necessarily be concerned about traffic count if in fact their access was solely to Alyeska Highway, for example?
Correct.
Yeah.
I think if that section of the code were looked at and actually deciphered line by line, and if it were challenged, somebody could, or maybe could challenge that to say that I'll ask the zoning itself was intended to have Alyeska Highway access for that particular zone that fronts with the, all right, that fronts or will have frontage on Alyeska Highway. But that's not in there. It's generally construed to mean it's the entire lot. And it's because the lot is next to the Alaska Highway. This is what it's set up for as a GR1.
Could you say it as simply as this? There's insufficient evidence to conclude direct access to Alyeska Highway or Gunny Sack Road is not feasible.
Yes, that's the first part. But then don't we want to direct them to look at the traffic impacts to Gunny Sack Road and consider the maximum feasible mitigation? I think that's the second part of it.
Okay,
Can that be added?
yes.
This, I think, would set the stage for what P&Z would need to relook.
Okay, and it probably should say the traffic impacts to Sproat and Gunny Sack Road. Is it?
Well, you've already got a remand for traffic on Sprout, so I don't know that you need to call it out again here.
Okay.
Mr. Wheeler, could you please read that for the clerk one more time?
Yeah, I'm trying to type up the second sentence. Give me a second.
I'm glad you're typing because I can't read my writing.
So I'm trying to make this as simple of wording as I can. So I don't know if this captures the intent here, but let me try. This is the second sentence only. If access to Gunny Sack Road is feasible, PZC shall take evidence on mitigation options. And make appropriate findings therefore.
What I was aiming for is evidence of the traffic impacts to Gunny Sack Road should be entered into the record to ensure that resulting mitigation is to the maximum extent feasible. So I'm not just concerned about the possibility of a driveway onto Gunny Sack Road. I think it's also important to look at the additional traffic that will be using this, what we're told, is very substandard road in terms of grade.
I'm not sure I'm following. Can you try that again?
Evidence of the traffic impacts to Gunny Sack Road should also be entered into the record to ensure that the resulting mitigation is to the maximum extent feasible. And maybe does that not address the possibility of a driveway? I intended to address the possibility of a driveway onto Gunny Sack Road, as well as just, can this Gunny Sack Road need any improvements, given that it's going to have more traffic than permitted uses would generate? So it could say evidence of the traffic impacts and or a driveway.
All right, I'm gonna try it this way because I'm not sure that I want to call out the driveway specifically. I'd rather just focus on access.
Okay.
So the first sentence is, there is insufficient evidence to conclude direct access to Alaska Highway or Gunnysack Road is not feasible. So then, if access to Gunnysack Road is feasible, PZC shall take evidence on traffic impacts and make appropriate findings on implementing mitigation to the maximum extent feasible.
That looks pretty good to me.
That encapsulates what we're talking about. That's, from my perspective, it hits it.
So there's one point that I apparently am seeing, and maybe I'm off base. This increases the use of Gunnysack. If traffic comes out onto Sproat Road or Gunnysack Road, there is additional wear and tear and turning movements and all that on Gunnysack Road, which is substandard. And so often when a developer uses adjoining substandard infrastructure, there's some improvement required to the infrastructure. And so that's what I'm trying to get at.
Well, yeah, in fact, that's some of the testimony that's already in the record, that the primary reason why Gunnysack Road wasn't an option for the property owner was because of the expense of bringing it up to standard. In addition to testimony regarding slope and so on. So that issue of feasibility will be considered. And that feasibility includes what are the standards applicable should this development use Gunnysack Road as its primary point of ingress and egress.
Yeah, but you're still missing my point. If Sproat is the primary ingress and egress, the traffic is still going to be going down Gunnysack Road for the most part. That's the quickest way out to the highway, which is where most new residents will be going. And so it's increasing traffic on a substandard road. And if it's a gravel road, it may need some kind of cappings because it's going to be more dust. I don't know if we've captured that in our previous discussion, or it may need, I don't know, signage, or it may need, I'm not sure, but it's not just the question of a driveway onto Gunnysack Road. This use is going to increase the traffic on Gunnysack Road, even if there's a driveway on Sproat. And that's what I was trying to get at in terms of mitigation.
Okay, if that's a option that they need to look at, what they're going to find is that they'll have to implement the standards to bring that portion of the road up to either collector standards or something else. And that's, we've already discovered that the Sproat Road has been designated a collector road. So that is the part of the reason why there was a variance in the record dealing with how to handle or trying to come up with a different use other than what's required for that road upgrade. So that same thing would have to be done or considered and brought into perspective with Gunnysack with the wording that we have in place.
Nancy, I would say, Nancy, that as far as I can tell from what's been filed in the appeal, there isn't a challenge premised on the idea that Gunnysack is going to have too much traffic on it with the currently proposed access point. So I'm not sure how you make that an issue here.
But Mr. Wheeler, but wouldn't that be included in the information that we're requesting, which is more traffic analysis? And that traffic analysis would have to look at what is required for Gunnysack, if it's going to be, if that has to be brought up to collector standards, or what would that be addressed within the information that we're requesting for traffic information? Because we've named the roads.
I think the way I understand this is that issues regarding traffic internal to the subdivision, for example, using Sproat Road, have been addressed already. For example, you have the variance request that was granted. There hasn't been an appeal of that particular issue, right? So the variance has been granted. The issue is whether the traffic generation is incompatible with the adjoining neighborhood. There hasn't been an allegation that the traffic generation requires some upgrade to Gunnysack Road because of the access point at Sproat. That's what I'm concerned about, is how do you make that leap to that being an appealed issue?
Mr.
Okay.
Wheeler, if you don't mind to state the second sentence again. So I think I understand what Ms. Pease is proposing, but I would like to see whether this language is sufficient for that, if you don't mind.
Okay, so my second sentence at the moment is, if access to Gunnysack Road is feasible, PZC shall take evidence on traffic impacts and make appropriate findings on implementing mitigation to the maximum extent feasible.
Okay, thank you. I think the issue is that if it is deemed to be not feasible or presented as such, it doesn't make Gunnysack Road now absorbed from the traffic. So there are going to be impacts on that particular roadway. And based on the information we have in the packet, we have been looking at a variance request for Sproat Road, which is part of the record, which was basically a variance to actually negotiate the standards down from what they would be if you implement them as they are. So, so I think potentially there is an issue here that we started the second sentence by an if statement being an access to the parcel being feasible on Gunnysack, but there is a second part of it that is there a mitigation needed for the road itself, regardless of where the traffic is going to enter that site?
That's my concern. Maybe we've already addressed it in asking for traffic impact analysis under criteria 6, but that was more geared at traffic counts. And so I just wanted to make sure that where the traffic is going is also considered.
And I'm trying to draw the distinction between traffic impacts on the neighborhood versus traffic impacts on the road surface. I think those are two different issues. And as far as I can tell, given the way this case has come to us, traffic impacts on Gunnysack Road itself are not at issue.
So
The only way they come to be an issue is if we get back to this discussion about using it as the primary access point.
okay, so if traffic but under our previous finding, if traffic on Gunnysack generates dust, for example, or traffic noise, then it's a concern. But if it causes wear and tear or dangerous driving conditions on the road, then it's not a concern. That's the way we've framed this up. We don't care about impacts to the road or driving conditions.
I think what would happen is if
I mean, I'm saying that we don't care. We have not found a way to express that. I care.
I think you care. I think, however, that what happens is if in the scenario where Gunnysack becomes the point of primary access, then the standards that would be applied come into play, and those are developed and applied at a different level by different agencies, etc.
Okay, well, I guess I have raised my concern that the traffic impacts to the road and driving on Gunnysack haven't been addressed to my satisfaction. And what I hear Mr. Wheeler saying is the appellant didn't raise that. And so therefore, we shouldn't raise that unless the driveway goes onto Gunnysack Road. Is that what I hear?
Mr. Wheeler?
I'm sorry, I thought you were asking the group.
Go on.
Yeah, well, I guess what I'm saying is, I've stated the concern about the impacts to Gunnysack Road infrastructure and to Gunnysack Road driving conditions. And I think I've heard you say, well, the appellant didn't raise that, so it's not in my bailiwick to raise it either. And so therefore, just word it the way you have, which is if the driveway goes onto Gunnysack Road, then we look at the conditions on Gunnysack Road. Is that what you're recommending as legal expert?
Yes.
Okay, so I, being the rookie here, will defer to my fellow board members on this one.
Well, this is the chair. I'm okay with the way the wording is stated now, and I think it puts the information, it'll put the required information that we need or should see in the record, or see them consider at least, will be developed through planning and zoning, and that should be developed through a remand. So I have no objections to the wording of the finding now. So any more objections, Ms. Pease?
Nope.
Mr. Diak?
Nope.
All right. With that in mind, the finding number 17 is approved. And Dennis, we need to get that to the clerk. Oh, wait a minute. You're all right. You can take care of that.
Mr. Chair, it is
Yes.
3:37. You probably need another motion to extend.
I move to extend. Do we want a time certain? 4 o'clock?
About
Probably need 4:30.
4:30, I think, is a
Well, we
good
can
time.
meet that. I move to extend to 4:30.
Okay,
Second.
motion been made to extend to 4:30 and approve and seconded. We're ready to vote, Madam Chair.
Mr. Stewart,
Yes.
Mr. Diak,
Yes.
Ms. Pease,
Yes.
the motion passes.
Okay.
Mr. Chair,
so-
before we move off criteria 7, I did want to see if we wanted a finding with regarding the vegetation, because we don't know the answer to whether here's what I would propose, just informally, that we find that 3MJ's retention of 25% of native vegetation was offered as mitigation application, but the Planning and Zoning Commission did not formalize that as a condition of approval, and it should have as a part of the maximum feasible offset for density. That's the gist.
Okay, so what you're doing is boiling it down to the issue of whether the promises made by the applicant in the application should be adopted as or treated as standards for the conditional use permit.
Yes, I'm not clear on whether the application binds them. Since it's not indicated on any site plan, it's just in the text. So I'm just trying to, since we get one crack at this, make sure that it's part of the mitigation.
Mr. Chair, if I may, appellant under number 7 specifically brings up this issue about tree clearing. That is actually the issue which seems fairly significant. The tree clearing to make room for development has already occurred. this property at this property, and vegetation was removed to the adjacent property lines, leaving no buffer to protect them from development. That is a statement which is not substantiated by anything in the record, but we do have it in the record that the petitioner committed to retain 25% of the vegetation on site, and I think a finding to that effect would be reasonable. I would agree with Ms. Peace on that. I would not necessarily jump to say that I know the exact wording, but maybe that would be the next step.
I think the way you phrased it would work.
So finding would be then that that appellant states that tree clearing has taken place in
No, I don't think we can do that because that information was not in front of the board and not part of the record.
Correct. That's why I'm
But
saying that that what we do know in the record is that there was a commitment to a 25% retention, and
Right.
And what I hope to infer here is that we are no judge of how that happened, but we definitely can look at the record and see that that actually exists in the record. And since it was part of the appellant's case, I think we should probably address it in some way. And then one way to address it would be that the Board of Adjustment finds that the petitioner committed to retain 25% of the native vegetation on site. But there's no evidence of including that as part of the conditions of approval.
Okay, I think that would work for a finding, but in order to keep it simple, we stop right after the site, but then it raises the other issue of whether that commitment should become part of the approval. I think that's another issue. Or can we combine them?
May I offer a suggestion?
Yes.
Yes.
Planning and Zoning Commission shall include as a condition of approval the applicant's agreement to retain approximately 25% natural vegetation, if doing so is necessary for purposes of enforcement. Right?
Yeah, I think that works.
That's your concern, is that
Yeah.
while they volunteered to do it, that doesn't mean they're compelled to do it unless you have some way to enforce it. And I wasn't able to find the language I was looking for. It may still exist. So this is sort of a play saver for that. If they have a legal determination from the municipal attorney's office that they don't need to make it a condition because it's already part of the application, then so be it. But if it does need to be a condition, then we're asking them to do so that it's enforceable.
Okay, so
Okay.
include the applicant's commitment to retain 25%, approximately 25% of the native vegetation on site if that, as a condition of approval, if that is necessary for enforcement?
Yeah, we'll put municipal enforcement in here. Municipal. Okay. So I'll say it one more time. The Planning and Zoning Commission shall include as a condition of approval the applicant's agreement to retain approximately 25% natural vegetation, if doing so is necessary for purposes of municipal enforcement.
Sounds good to me.
Okay. I'm good with that. Mr. Diak?
Would this be a finding then, number, I think, 18?
Finding number 18.
Yeah, I'm good with that.
Okay. Any objections to what Mr. Wheeler has read and approving that as a finding number 18? All right, finding number 18 is adopted. Okay. Do we have any other issues before we go back and look at motion or the issue number 5, which was the overarching one?
No, I think we go back to it, but please restate it for me or point me to where.
Motion was the P&Z or Planning and Zoning Commission did not err in deciding conditional use permit application met the conditions for issuance of the conditional use permit.
Mr. Chair, is this the only motion left? What you had a couple others, right?
Well, I was going to go back and maybe look at a couple more just findings, but we want to deal with this motion.
So I wanted to look at criteria 1 again. And so should that come first? I mean, you stated we were going to go back to criteria 1.
Okay, that's why I asked if there's anything further. Criteria 1, okay.
So the reason for going back is that the appellant raised a question, ostensibly, he phrased it as relevant to criteria 6, but it has to do with affordability. And I thought it has to do with criteria 1, compatibility with the Girdwood area plan, because that's where affordability is stated as an intent and purpose of the zoning district. So when we considered criteria 1, we didn't talk about the language on page 48, which states community-based family housing should be dispersed, low in scale, blend in with small town atmosphere. This type of housing is intended to be affordable and to be available for both seasonal and full-time residents of the community. So just different from resort-based family housing that is likely to be oriented toward the, resort users or employees.
Okay, but there's no criteria.
No, there's not. And the appellant gave some price ranges. These units are expected to be in the $650,000 range, but the applicant didn't give any evidence as to what is the range of seasonal and full-time residents of the community, what is affordable. So it's not documented. The applicant hasn't documented at all. The applicant has just raised this concern that these are supposed to be affordable. And yes, the Girdwood area plan does say affordable housing. That's what this type of housing is supposed to be. But the applicant hasn't documented whether these units as designed and priced are affordable or not. So again, who does the work here? Is this our responsibility or not? Is this evidence that the Planning and Zoning Commission should have requested in order to make a determination of criteria based on criterion 1?
Well, I think we'd have to have something that's more closely related to the criteria, more directly related rather than the intent that's expressed in the Girdwood area plan. And I'm looking for, I think there was a section in here that talked about affordability, and that it was not raised, or was it? Okay. Well, the only thing that I can see where it talks about housing affordability is there is a formula or a section in definitions that talk about how you define or find out what housing is affordable for a particular location.
Mr. Chair, where are you looking?
It's under the definitions.
So 2115-030.
21, is it 14? If you go to the H section.
14 or 15? You're talking about rules of construction and definition, chapter 2115.
Oh, okay. Yes, it's rules of construction and definition. I think my written code is a bit outdated. Yeah, it's I think it's in there, housing, affordable.
Yes, it is. So the first sentence, housing that has a sales price or rental amount that is within the means of a household with a low or moderate income as defined by federal code. There's some additional definition around whether or not the housing is for rent and what that calculation would look like.
And then further on down, does it talk about in case of the dwelling units for sale?
In the case of dwelling units for sale, affordable housing means housing for which principal, interest, taxes, insurance, homeowners association fees, and assessments are no more than 30% of the gross annual income of households earning less than 80% of the median annual income, adjusted for household size, as determined by the Federal Department of Housing and Urban Development.
Okay. So I guess my point is this something that it could have been done or addressed, but is it something that we can look at that would require them to have this looked at?
That is the big question, right? So when I think of this and look at the sentence in the Girdwood Area Plan that says this type of housing is intended to be affordable, I then think about, okay, well, how is that intention being implemented in any implementing code, particularly any implementing code for a conditional use permit? So think of it this way. If the applicant had wanted to build 4 housing units, whatever the by right limit is, 4 or 5 for this, there would be no discussion of affordability.
You're
right.
Because that would be by right.
Well,
Correct.
So, Mr. Wheeler, with all due respect, it says community-based multifamily housing. So it seems to me that
correct.
Any multifamily housing would need to be affordable.
No, that's my point. Because they could build multifamily housing on this property without needing a conditional use permit if they went for the lower limit. And there'd be no discussion of affordability. There would be no requirement. So if you're going to impose a requirement of affordability just because they're asking for a few more units, how do you get there? How do you connect this sentence to any code requirements for conditional use permit?
Miss Pease, maybe we can step back for a second, because that's what I've been kind of contemplating as well. I reread several times page 48 of the land use Girdwood land use plan, and the intent is clear. There is this type of housing which is desired in Girdwood. I don't think that has changed 25 years, although I see no evidence in the record to tell us that was one of the issues. On the other hand, if you just develop multifamily units by right on this particular parcel, that would result 5 units. you could build a 5-plex, maybe with the same configuration of units as shown, and there would be no discussion about this issue at all because it's by right. So the question is the conditional use permit in some way need to address affordability because it is asking for an additional, I guess, remedy from the land use code, or additional support from the land use code to fulfill certain goals. And I think what you're looking at is that if you are doing it by right, then it's by right. But if you are doing it with a conditional use permit, which requires a higher standard for approval, then should this be a part of that discussion? And I'm paraphrasing you, but I think that's where you're heading.
Right, and I'm I'm unclear on that, whether the affordability is kind of, if there's a required public benefit to come out of a conditional use, or whether the conditional use is just to mitigate adverse impacts. And I'm not sure there is a requirement that the conditional use show, a public benefit such as affordability.
Well, if you take it to the extreme, if you look at this particular lot and there's one person that wants to come in and build a 2-story or maybe even a single-story big palatial building or home, and it would cost $1 million, would that affordability come into play as long as they met the rest of the requirements?
I wouldn't.
No,
it's by right.
It's by right. And so I guess my question is this: is there any obligation to meet affordability for those extra units, or it looks to me as if a conditional use? Yeah, I can't tell. It's supposed conditional use. A lot of the conditional use permit criteria have to do with mitigating impacts, but criterion 1 says compatibility with the land use plan. So,
but I would look at it as what is allowed under the current zoning as a right. And if you're allowed to do it as a right, what you're doing with the conditional use is that you're saying you're going to change something that is going to affect the basic by right. You're going to change that, and that there may be some adverse impacts, and that needs to be looked at, and how it's going to be, whether or not it's going to blend into the community or whether it's not going to blend in, and whether it's going to be compatible. So unless we can get to beyond the, I think if we don't get beyond what is allowed by right, I don't think you can apply a different standard for a conditional use, because you have to look at it as, in my perspective, as the right is there. So you've got the basic right. That sets the plateau. If you want to go beyond that, and you've got the right, affordability does not impact the right. So it's not going to be addressed as part of conditional use, but you're going to look at what the conditional use is going to do and how it's going to impact what is by right given to you as a lot owner under GR1.
Mr. Chair, I would like to use your example, but come to the exactly opposite conclusion. And the reason for that is because there is no requirement by any landowner to seek any kind of public planning remedies to change the by right use of a parcel. So therefore, looking at this parcel being by right 5 units, there would be nowhere near a long meeting like today to discuss that project. So when the conditional use is put in place, it's put in place exactly with the intent that there is a higher standard to meet here, because what you gain from adding additional units has different impacts, and therefore it gets reviewed under all those conditions. And if that condition wouldn't matter, it would not be part of the approval criteria of the 9 approval criteria. And number 1 clearly states that we have to look at the comprehensive plan, and in this case, Girdwood area plan, to be a part of the approval condition. That's not applicable to the by right use. You don't have to look at the Girdwood area plan because you by right developing. And I think that is where this question of number 2, talking about affordable housing and us acting on that, and now looking at number 1, whether that should be included in this discussion. And I think the question is, do we make a finding on this, or how do we address it? And this is where I'm looking to Ms. Pease, because I'm not decided on which way we would want to go on this, but I do understand the issue. Or at least I will sound like I do.
Mr. Chairman,
Yes,
may I play devil's advocate for a second? So
Mr. Wheeler, go ahead.
what would be the consequence of saying that a conditional use permit for multifamily housing can only be approved if the housing is affordable? Would we read that as a reasonable requirement under the plan? So any multifamily housing by CUP in the Girdwood area would need to be affordable? I don't know that if that would be the correct way to approach this. Just playing devil's advocate here. How would you address that?
I don't think making that a criteria, I don't think that would make you have, or your property would not be marketable. You wouldn't be able to sell it if you had that affordability, because anybody that would independently come back and say, well, it's not affordable, therefore you violated my rights, now I'm going to file and I'm going to try to get some remedy. It just doesn't seem like it's a practical thing that can be remedied through the process that we're looking at right now.
How does this relate, if at all, to development approvals that require a certain percentage of the housing to be built at market rate or at affordable housing? I mean, this is something that large developments elsewhere in the bowl have had as a condition. Is that not correct? And are those? Yeah, I haven't been paying attention to other multifamily approvals, but there are instances where the developer is required to add either, well, another comparison would be in mixed use, where a developer has to put in some residential along with commercial. So there are, I guess what I'm saying is, yeah.
Yeah, I do think, Ms. Pease, I do think that you are correct in that some developments certainly do have considerations for affordability, and actually the code does have sections where affordability does is stated as a criteria to get other criteria to be satisfied. But in this particular case, I think we need to state what we are interested in without solving the problem. And the question here is, do we have anything to say about after the deletion of number 2 and making our own judgment on number 2? Do we have anything to say about affordability based on number 1? Because that's where number 1 resides. That's where affordability resides in the Girdwood area plan. And then if we do, then we either have to make a finding, which then directs the Planning and Zoning Commission to investigate that issue, or we're going to have to conclude that they have sufficient evidence here presented to us that they consider this issue and then basically treat it as not part of the appeal.
Okay, that's where you were going where I was going. what I'm seeing here is that's not our responsibility to correct the way that the zoning is set up under GR1. But it could be something that, and I like the way you put it, this is something I think that ought to be addressed and analyzed and considered by planning department, and get it in front of the P&Z to perhaps make some changes or address it at least.
Okay, so I think we've done our duty then. I think we could find that a conditional use approval for multifamily housing above the by right density in the GR1 should take into account affordability as outlined, or as this is a stated intent in the Girdwood area plan for GR1.
Well, I don't think I'm willing to go that far. I'm willing to go raise this as an issue and have it looked at for possible consideration by planning and zoning, or I'm sorry, by the planning department.
Okay, as long.
What is
I
the
guess-
construct for that, Mr. Chair?
Yeah, that's fine.
Mr. Wheeler?
Yeah, I think if I understand you correctly, you're not making this a condition of approval for purposes of this particular conditional use permit.
More like an advisement?
An advisement, yeah, and so when you get to your written findings, you could have a small section or a footnote regarding your decision that it's not applicable here, but should be considered as part of some sort of policy discussion and implementation, so that there's a clear understanding of how that's being implemented and whether or not it applies to the conditional use permit applications such as this one.
Okay.
So if you make a finding regarding affordability, you can ask that we do a footnote addressing this as a broader policy discussion.
I like the way that you phrased it right in the very beginning, because you had it capsulated. We put it in a finding with a note on the bottom.
Right, so you make the finding as to whether or not affordability is an issue here. And then when we get to penning the final decision, we'll know from the recording and the record to add the footnote.
As a caveat, right? Or an advisement?
Advisement's fine.
Okay. Is
I
that,
I would offer a finding then, if that helps this process along.
Yes, please.
The Board of Adjustment finds that the Girdwood land use plan intends to promote affordable housing for community-based multifamily housing. And that's it.
You meant the Girdwood area plan? I don't know. Anyway, land use plan. Yes, land use plan, sorry.
Correct.
Yep.
And those statements are coming up from paragraph 4 of page 48. And that's the issue what we're dealing with and the type of housing we're dealing with.
okay, would you say that again?
Yes, the Board of Adjustment finds that the intent of the Girdwood land use plan is to promote affordable housing for community-based multifamily housing proposed by the developer. Let's go proposed by the petitioner. Let's add that.
Okay.
So if you look at this from the other way around, what you're trying to say is you think the board, or you think that the Girdwood area plan indicating affordable housing is a requirement for
No,
conditional.
I did say that because we're going to have a footnote which will talk about implementation, which Mr. Wheeler referenced, that the footnote of this finding will be that that I'm not sure if we use the word request the planning department to propose solutions, or I'm not sure how Mr. Wheeler phrased it, but that would be the footnote, the implementation part. All I'm doing is making a finding that this particular issue exists.
Okay, we're implying that it is part of the code requirements for conditional use.
Intent.
Actually, I'm not implying anything. I
Yeah.
actually clearly state that the intent of the land use plan is what I stated.
The intent, yeah, that's, I think, a good word choice.
Okay, Mr. Wheeler, does that work for you?
Yeah, here's what I wrote that echoes this. The Girdwood area plan intends for community-based multifamily housing to be affordable. However, there are no implementing provisions in municipal code applicable to this specific application, and therefore affordability is not a criteria upon which to grant or deny the permit.
Okay, that sets the stage for having the planning and having the municipality relook and reconsider everything involving affordable housing.
Right.
I'm okay with that.
I'm thinking, but I would also state that this particular issue we're dealing with right now is there because we have addressed this issue of affordability on condition number 2, and we acted on that. So this kept this particular issue open. And I think stating that currently there's no code requirements to implement this in this particular zoning district, that's factually correct.
But then the last sentence, I think, went farther than that in my mind. Could you reread your last sentence, Mr. Wheeler?
However, there are no implementing provisions in municipal code applicable to this specific application, and therefore affordability is not a criteria upon which to grant or deny the permit.
In other words, that says it's not clear in the code, therefore we can't implement.
There's nothing in the code to implement.
No,
Yeah.
I mean, that's the problem.
Okay.
Mr. Wheeler, how does that work with this idea that again, on by right, this would be absolutely no dispute on this discussion, but when you go into conditional use, you stated that because it is not part of the zoning district by right, then it's not part of the conditional use application either. Is that I think that's where this whole issue stands.
Right. So the conditional use has the 9 criteria. None of those 9 criteria speak to affordability. So as Ms. Pease pointed out earlier, the conditional use permit process is not designed to solve a public problem such as affordable housing. It's really something that the landowner would like to do, and the municipality is open to considering it as long as there's mitigation. That's basically what you're talking about with a conditional use permit.
So how does that mesh with this again criteria 1, which then opens up implementation of the land use plan, which does clearly state the intent for affordable housing?
You have an intent without a demand or a requirement, without any articulation of how to meet that intent. So the intent is not saying every single multifamily development has to be affordable. The type of housing is intended to be affordable. That doesn't make it so, or doesn't make it a requirement.
Would you mind to reread the whole finding then?
The Girdwood Area Plan intends for community-based multifamily housing to be affordable. However, there are no implementing provisions in municipal code applicable to this specific application, and therefore affordability is not a criteria upon which to grant or deny the permit.
Thank you.
So basically, I don't want to set a powerful precedent here. Maybe it's already been set. That says anything in a plan that's not carefully, legally codified shouldn't be followed. I think that's dangerous. I'm not comfortable with stating it quite that way.
I think that it is followed, but it's followed in the intent of how the boundaries and the rest of everything is set up in the 2020 plan, the comprehensive 2020 plan. If you look at what is in the 2020 plan, you know, there's a discussion of boundaries and how the intent of other plans fill into it. And I think there's a whole different discussion. And I think that is more properly raised the way that Dennis has stated, or Mr. Wheeler stated this finding. But I'm trying to figure out a way that I think this needs to be in some of that explanatory wording on the bottom as a note when we have our findings and decision. So it raises the specter for the municipality to, hey, we've got an issue here, you need to look at it.
Yeah, right. I guess maybe if it could be softened a little bit to say something like it's you know, beyond planning and zoning can't apply this as a requirement. It doesn't mean that it's, I just as I said, I don't want to emasculate the intention of the plan or future plans by saying, unless it's been spelled out to the letter in code, you can breeze by it. So I don't know whether there's another way to say it that doesn't disempower the language of the plan, which Mr. Wheeler's last sentence seemed to me to do.
Well, there's no implementing procedures, so how is that handled other than the way the finding is worded right now and put notes in the bottom to bring it to the attention of the municipality?
Mr. Chairman, if I might, Ms. Pease, Tomas Diak mentioned this earlier in terms of implementing code, but you can imagine that the Anchorage comp plan has other plan elements that mention affordable housing and how that's a desirable attribute to the community as a whole. And that's been implemented in different ways in the code. So as an example, you can get an additional floor height in your building in a residential district under 2104-020 if you have 10% of the dwelling units affordable. So there are ways to implement it, but in the absence of that, there is some difficulty in trying to decide whether a conditional use permit should or shouldn't be granted when you have no way to based on affordability, when there's no criteria to use.
Mr. Wheeler, sorry, go ahead, Nancy.
No.
I just wanted to do another dip. So if you, I'm gonna make you like just be reading for me like this is a lullaby thing. But if you could just repeat that once more, I would like to just contemplate that, because there may be a way to do this.
Or if you could put it up on a screen, share a screen, that would be great.
The code section?
No, the actual finding with the additional.
The finding. Yeah, sure. Hold on a second. Let me put it in a standalone document first.
So I was good with you reading it, but okay.
Oh, no, that's all right. I'm there, just a second. All right, let me know when you should be able to see my screen now.
Yes, we do.
That's great.
I would offer something here for the second sentence, and that would be although consideration is encouraged, there are no implementing provisions in municipal code. Something along those lines, which does actually state that this should be an issue which we do think is relevant for considerations. And then from there, basically, you have the statement which states that current zoning regulations in this district do not make it a criteria, and therefore there is just like you stated. So that would be my hopefully reasonable way to solve this.
I think that's a good compromise, or a good, not compromise, a good
Okay.
solution.
Any objections to that?
Thank you, Mr. Wheeler.
Thank you. And I think the idea of typing these up on the screen should be a future technique.
Oh, as long as it's not me.
Okay. If there are no objections, and I see and hear none, that finding is number 20 and is adopted. Okay. I've still got issue number 5 open, right?
Yes.
Yes.
Okay. Well, considering our findings that we've done so far, I think this is an easy one for me to look at. And the issue is, the motion is the P&Z did not err in deciding the conditional use permit application met the conditions for issuance of the conditional use permit. I'm going to vote in opposition to this, because what we've done so far is that the P&Z did err. So Anybody else have anything to add?
No.
Okay. Seeing none, hearing none. Madam Clerk, would you call the vote?
Yes, Mr. Chair. Mr. Stewart,
No.
Mr. Diak,
No.
Ms. Pease,
No.
Okay, so that motion fails. So is there anybody that sees anything else that needs to be done?
Mr. Chair,
Yes.
I presume that I'll work with the clerk's office to get this all written up for your consideration at whatever time you set to do so.
Yes. Do we need to have a motion to actually change the P&Z resolution, or can you set that up as a conclusion for us in the findings and decision?
I'll set up the appropriate conclusion for you.
Okay. Madam Chair, how much? Oh, wait a minute. What I'd like to do.
Barbara, could you please mute?
In the whereases on our decisions, I would like to document the process that we went through to go through what happened with the delayed record and the order, and put that in the whereas, so that we've documented that for the record.
Yeah, no problem.
Okay. How much time do you need to work on this draft? It's going to depend on, I think, the clerk, on how much time it takes to get the information to you.
well, we have most of it in pretty good shape. So if you want to give us, you know, I think Jennifer would probably like a week, and like to set, that would give us enough time to set up another meeting. So if you could say anytime after 1 week or in 1 week.
Okay, and then how much time does that give you, or how much time do you need, Dennis, to put this together after you get the record or the transcript?
Well, if you give me the same amount of time, that should be fine.
Okay, so a week for each of you?
Yes, please.
Okay. That would take us into 1, 2, that takes us into after sometime in the, oh man, the 12th through the 16th of April. I'm trying to figure out, well, April, wait a minute. Okay, does you think we can do this on the 14th of April, 10 a.m.?
This is a question to members.
Yes. Does that, well, first of all, does it work with Mr. Diak and Ms. P's schedule?
My schedule's pretty open that day.
I can do 10 to 12.
Okay. With as many findings as we've got, is there another time that would be better for you?
We can start at 9.
Okay, is, if we start at 9, is that okay with the council and with clerk?
April 14?
The 14th?
Yeah, that's fine.
Okay,
That's fine. Jennifer and I are both open at that time.
okay, so we'll start at 9 a.m. on the 14th. Okay. All right, back to the agenda then. Item number 7, are there any member comments?
I just really appreciated that last instance in which Mr. Wheeler put up the finding on the screen. And if we can do that anytime we have to draft findings on the go, that really helps.
Okay,
Mr. Chair, I would like to express my gratitude to council as well as our support team from municipality at the clerk's office. And a small apology for running long, but thank you for all your help.
okay, and from my perspective, I appreciate everybody following through and sticking with us through this procedure. It's a little bit more difficult when you're operating through video conference. And I want to thank you for being patient. And I want a special thanks to Mike Crawford, the Muni IT, of helping me work through some video operational challenges that I had. And we got those bugs out. So regarding audience participation, do we still have audience here? It looks like we do. We got a lot of numbers are open. Okay.
Mr. Chair, you need to make sure that no one can speak to you about anything except this matter that is before you.
Right. Although this hearing is, and this is to the audience, this hearing is open to the public. But please remember, if you desire to participate beyond monitoring the hearing, you may not address or raise issues of cases that we've decided or this particular case that's under decision. And that's set forth in Municipal Code 21.03.050A10B. The Board of Adjustment shall not hear argument, take additional testimony or other evidence. So is there anything from the audience? Okay. Hearing none and seeing none, can I have a motion for adjournment?
So moved.
Second.
Okay, is there any discussion? Hearing none and seeing none, this meeting is adjourned. Thank you.
Thank you, Bob,
all.
for being a good boss.
Yes, well done, Bob. It was a long one. Thank you.
It was a
Bye-bye.
tough one.
Yes,
Thank you.
Bye-bye.
appreciate it all. Bye.